which is a private plan change to the Taupō District Council. In a minute, I'll introduce the hearing panel, but just to get us underway, Raruri, I understand that you're prepared to do a whakaaro karakia, so over to you to open us up, if you would.
Okay. Kia ora tātou. Tuatahi ngā mihi rā kia koutou, kua hono mai marunga I te hui tupa ki tēnei, mō tēnei kaupapa, ko tēnei ka mihi, kei te mahara hoki ki a rātou, kua kapuhia I te ringa o hine nui te pō, kei te mihi, kei te mahara. Tātou ngauri waihotanga o rātou mā tēnei, kei te mihi atu, tēnā koutou, tēnā tātou. Aha kua poto waiho tēnei kōrero, tikana te mihi atu kia koutou katoa, kua hono mai mō tēnei kaupapa. Kia tīmata, meno E tātou. Tūtawa mai.
We seem to have lost Rawiri. I don't know if that's a temporary thing or not. All right. All right. Well, let's proceed. And if Rawiri gets back on, then we'll complete that. Just to introduce the commissioners, my name's David Hill, and I've been appointed to chair this particular panel. And with me today are, let me introduce Commissioner Dale Hunia. Would you like to say something, Dale?
Kia ora tātou. Thank you.
And many of you will know Councillor Kevin Taylor. Kevin, would you like to just introduce yourself?
Morning, everyone. I'm representing the council as commissioner this morning. Thank you, David.
All right, thank you very much. Just yesterday, and I'll just do some preliminaries in a second. Unfortunately, as you can tell from my hair, I'm locked down in Auckland, waiting for a haircut for 3 months, and God knows when that's going to happen. Those of you who might have known me when I was a student will recognise that I look very similar to when I was a student many years ago now. So, but yes, it's unfortunate that we've had to conduct this hearing by virtual means, but I think those of us who are in the game are getting fairly used to doing that. So hopefully things will run fairly smoothly over the next couple of days. Even though I wasn't able to participate in the site visit yesterday, I guess I have some background in this general area. In fact, I think it was quite a long time ago now. I think it was 2004 that I was part of the team that reconsented Wairaki geothermal and also the Poihipi geotherm plant at that stage. So I've got a fairly comprehensive understanding of the underlying geothermal and geological nature of this particular area. I also chaired the hearing that granted Rangatira the Acacia Bay Neighbourhood Shopping Centre back in 2007. So whilst I'm not on the ground there, my head's very much in place. And of course, over many decades visiting Taupō as either to the ski fields or back from the ski fields. So whilst I'm a Jaffa and an unkempt Jaffa at that, I do have an idea of the general area. Just a few comments. It is a virtual hearing, so I think as well as I can see, the word has gone around. If you're listening in, please just listen in. Just have your mics and your cameras off unless you're actually presenting to us. That'll make it a little bit easier in terms of transmission for those of you who've got slightly less robust transmission. The submissions and evidence we will take as read. It's been provided that obviously we've received, thank you Mr. Maldoni, we've received statements over the weekend, summary statements which are going to be read to us as I understand, but all the other material we have read, so we will not be requiring either witnesses or submitters to read their submissions or any of their evidence. We'll move fairly swiftly to questions on that matter. We did excuse a number of witnesses on topic areas. They were contaminated land, ecology, urban design and landscape. And they're excused not because those issues are not important, but because between the technical experts, there really was no dispute at the end of the day, and they're satisfied with the proposed provisions as they've come through. If there's additional matters which arise during the course of the hearing that require those witnesses to be questioned, then we will do so. In terms of the site visit, Kevin or Dale, do you want to say anything about yesterday's site visit, which I understand was a comprehensive 2.5-hour walk over and drive around? So anything in particular that you'd like to comment on?
Thanks, David. Dale and I had a fairly comprehensive both drive and walk around. We focused quite a bit of our attention on the gullies and walked a number of those. It'd be fair to say we've covered pretty much north to south, east to west of the plan change area, and I've had a comprehensive look at most of it, bar one block which was covered in scrub, wasn't accessible, but got a fairly good mind map, for want of a better phrase, of the area. It's easy to read the words, look at the diagrams and photos, but it's another thing to actually be standing on the ground. So that was great to be able to do that yesterday. I don't know if Dale, you want to add to that?
Yeah, thank you. No, nothing further to add. It was really worthwhile, and we did have a good walk around as well as driving around and having a look at the whole area. So yeah, and thank you for those that helped us with that.
All right, thank you for that. I see, Rarwari, you're back with us. Can we go back to you and complete the introduction? Are you there, Rarwari? All right. Well, let's proceed then. There's two preliminary matters that Mr. Bonas raised in terms of his Section 42A report. And for those of you who got the document, it's on page 16, where two matters that he's raised for our consideration. The first is whether or not to accept submissions 56, 57, 58, and 59, which came in whilst they were sent. They seem to have gone through a slightly different portal. And we don't have any problems, I don't think, in terms of receiving those. As Mr. Bonas says in there, they don't raise issues that are not already on the table. So there's no prejudice arising, but I just confirm with you, Mr. Maldoni, that you don't have a problem with that.
No, that's perfectly fine, sir. Thank you.
Thank you for that. So those submissions are accepted. The second matter that is raised is submission 33 from GNR Brendan from Ripakama Trust, seeking the inclusion of 63 Watani Lane into the plan change area. And Mr. Bonas's conclusion on that is that that submission is not in scope, and his recommendation for that is that we reject that particular submission. And Mr. Maldoni, you have a view on that?
Only to say that I agree with Mr. Bonas's conclusion regarding scope, sir. So I don't consider it on the plan change in the classic sense. So would agree with the 42A recommendation.
All right, fellow commissioners, do you have any problems with the conclusion on that matter?
No problem.
All right, right. Well, we'll determine then that submission is not on scope, not in scope, and therefore is not accepted. So submission 33 is declined. I think in terms of preliminaries, that's all I need to go over. So, Dale, Kevin, any matters that you want to raise before we head off into the wild blue yonder? No?
No, happy to proceed.
Right, Mr. Muldowney, over to you in that case.
Thank you, sir. Kia ora tātou. So my name's Lachlan Muldowney, and with me, just out of shot, is Ms. Thomas, and we appear for the applicants to the plan change. So we've, as you've said, there's been a bit of material sent in over the last few days, and as is always the case, I'm reluctant to burden the commissioner group with additional material, and certainly have been conscious of that concern. But there are certain matters that you'd responsibly want to hear from the applicant team on, and in terms of reply to some of the evidence filed on behalf of various submitters. So rather than simply ad-libbing or and delivering that information verbally, it seems more efficient and clearer to have committed it to writing and submitted it to you. So that's the simple purpose of the additional material, and I hope it assists in terms of a smooth running of the hearing. Yep. So what we had intended to do, sir, as you have signalled, is most of the witnesses for the applicant team have presented a statement of evidence, which includes at the beginning of the statement a summary of their evidence, and it usually runs to 6 or 7 paragraphs or thereabouts. So what we intended to do was simply have each witness go to that summary section of their statement of evidence and read that summary. And then if there is a reply statement that some of them have, they'll switch to that and then just read the reply statement, and then just go straight to questions. So I hope that's an efficient way for us to proceed, and just checking in that you're okay with that.
Absolutely, and that's fine. And we've had the opportunity over the weekend to read all of those summaries as well, so that's helpful. And we did receive your opening legals about half an hour ago, so thank you for that. Yes. As well.
Thank you. So yeah, we'll just work through the witnesses in the order that I think has been signalled to the council. And the only other thing I was just going to say was that there's a couple of witnesses that didn't have summary statements in their primary evidence, and we've filed those as well so that we can go straight to it. So hopefully it will assist in moving through the evidence crisply and getting to the critical issues. We've got, as I said, opening legal submissions, and what I intend to do is read from those submissions, but I'm also conscious of the fact that much of the ground covered in the submissions, particularly around the law and the plan change process and so on, is obviously well understood and well known to all of the commissioners. So I won't drag you through those parts of the submissions. So I'll skip certain parts, but there is a central part of the submissions which deals with what I say are the key issues, or the issues in contention. And I do want to just walk carefully through that particular section. So that's really the roadmap, sir. That's how I intend to do it. So I'm hopeful that we can get through the opening submissions in potentially half an hour, subject to questions, and then get straight into the evidence.
Good, thank you.
So if you have the submissions in front of you, sir, I'll move to that. Can I just quickly say the applicant team is all on Zoom at the moment and sort of queued up and ready to go, so to speak. Those witnesses that you did excuse are on standby, and so they know that if they do get an urgent phone call or a text, that they'll need to dial in and be ready to answer any questions. But we've got the core team that you've asked to hear from here today, and all available.
Good.
So to the submissions, in terms of the introduction, PC7 represents a compelling opportunity to enable an attractive, livable and high quality residential neighbourhood in the Nukuhau area of Taupō. Long established as a future urban area, Nukuhau's time has come. The plan change, which is sought by 3 landowners in the area, who I'll describe as the cooperating landowners or the applicants, seek to rezone 77.78 hectares of rural environment zoned land to a mix of general residential environment and medium density residential. The plan change is consistent with the well-established strategic planning or strategic growth planning in Taupō. It is consistent with Taupō District 2050, which is the long-term urban growth strategy for Taupō. Nukuhau area is identified as a northern urban growth area in the operative Taupō District Plan, and under the district plan, such areas are where the majority of growth is intended to occur in the northern area of Taupō. And then at the regional level, the Waikato Regional Policy Statement gives statutory life to TD 2050, and the plan change gives effect to the regional policy at 6.11 of implementing the Taupō District 2050 by enabling residential growth in Nukuhau. So in my submission, there is very good alignment between what is being proposed under Plan Change 37 and those broader long-term strategic growth strategies which are directing how growth should be managed in the Taupō District. The plan change delivers a residential community which will make a demonstrable contribution to growth within Taupō in the right location and in a compact, coherent and efficient way, which sets this community into the landscape, protects key environmental features and makes and creates neighbourhoods for a broad, diverse community. The structure of the submissions I've set out at paragraph 5, and as I say, what I've intended to do with the submissions is firstly summarise the plan change proposal. Secondly, just address the procedural background, which we'll move through quickly, and then outline some of the proposed amendments to the plan change since notification, generally as a result of issues raised in submissions in the Council Officer's report. Then I'll address what I say are the key issues, and then there's a brief statutory analysis of the plan change, largely with reference to Ms. Cleary's primary planning evidence. In paragraph 6, I've described the plan change proposal itself. It's primarily seeking to facilitate residential development through the proposed rezoning of approximately 78 hectares of land from rural environment to general residential environment, and approximately 8.3 hectares to medium density residential environment. There is also a neighbourhood shopping centre overlay of approximately 2,500 square metres, also proposed on the western side of Acacia Bay Road. The plan change area is located on the immediate northwest of the Taupō urban boundary on elevated southward sloping topography. The plan change area is ideal for the residential development proposed, being currently comprised of pastoral farmland and a limited number of rural lifestyle allotments containing a modest number of existing dwellings. The plan change area is well located to ensure a compact urban form as an extension to the existing urban area, being only 2 to 3 kilometres from the Taupō CBD via Wairaki Drive and the Control Gates Bridge. The proximity to the Taupō CBD and Lake Taupō means that the plan change will provide good accessibility for future residents to employment, services and recreational facilities. PC 37 will make a positive contribution to a well-functioning urban environment to provide housing choice and opportunities for active transport modes. Extensive open space and stormwater reserves will provide a high level of visual and recreational amenity for residents. The creation of walking and cycleways within the main gully systems within the structure plan and the enhancement of these areas with planting will achieve a high level of amenity for residents and ensure the low impact stormwater design concept for the structure plan is fulfilled. The paragraph 7, I've set out the essential parts of this plan change and don't intend to read that. It'll be well familiar to the commissioners by now. Yep. paragraph 8, I make the point that the plan change has been amended to incorporate many of the recommendations made in the officer's report and in response to submissions. In addition, the officer's report sought a small number of amendments to the applicant, which the applicant supports in general terms, but have made further changes to ensure a workable set of provisions. And those amended provisions form of the plan change are appended to the evidence of Ms. Cleary in her primary statement. There are a couple of further amendments that Ms. Cleary is recommending, which have been identified in her summary statement and reply evidence. But by and large, they're relatively minor tweaks to what you see appended to her primary evidence. In terms of the procedural background, I didn't read that in full, but I've set out at paragraph 9 a sort of a broad description of where the submissions landed: 12 in support, 44 opposed, 3 not taking a position. And at paragraph 10, I've identified some of the issues that have been identified by the submitters. There's the bike Taupō submission, which doesn't oppose the plan change, but does seek an amendment to a policy to provide for cycling infrastructure. There's some planning and technical evidence from Waikato Regional Council, which seeks amendments to the plan change in relation to gully management. Largely, those issues have now been, we think, resolved in terms of some of the amendments and the response that the applicant has provided in terms of the Regional Council's evidence, and we'll take you through that in due course. There's the planning evidence from Contact Energy, which advises that its reverse sensitivity concerns are being worked through directly between the parties and are likely to be resolved. Now, on that front, I can say that there has been ongoing progress over the weekend. We don't quite yet have a landed a position that I can say has squared everything away, but it's all tracking very, very positively. So I'm hopeful that before the end of the hearing, we're able to confirm that the Contact Energy issues are all resolved.
Yeah.
There's archaeological evidence from Heritage New Zealand, which seeks resolution of matters raised in the archaeological peer review appended to the officer's report. Now, this is an issue that I will address you on. There's I guess you'd say, a little bit of skirmishing between the experts on the appropriate timing of certain further investigatory work that they say is necessary in order to square away heritage items. With Heritage New Zealand and the technical report from supporting the officer's report, suggesting that some of these issues should be hunted down and solved prior to the plan change being approved. Whereas the applicant says, no, we've done enough in terms of identifying and understanding those heritage items to enable the plan change, bearing in mind that there'll be some assessment criteria which get applied at subdivision and earthworks and development stage, which can chase down any residual issues. So again, that's a matter that we'll take you through. There's also the planning evidence from the Rangatira blocks 8A17 and 8A 1T2X and so on, described generally as the Rangatira 8A17, which is supportive of the plan change, but does seek some amendments, one being the removal or at least adjustment of the location of the neighbourhood shopping centre overlay, and some amendments to the stormwater reserve notation along the southwestern boundary of their site to a 3-metre landscaping strip. And again, I'll work through those issues in a little more detail shortly. Yep. And also planning evidence from Rangatira E, which opposes the plan change, but largely on the basis that it prefers to see its development aspirations enabled ahead of the plan change. And again, I'll work through a little more detail about those matters shortly. The officer's report concludes with a positive recommendation to approve the plan change, but subject to amendments. I won't read those sections, but I think it should be very apparent, I'm sure, to the commissioners by now that probably the most significant caveat, if you like, that's attached to the recommendation to approve the plan change by the reporting officer is the issues concerning the Control Gates Bridge and the potential for declining levels of service associated with that piece of the transport corridor if the plan change was approved, and how to deal with that issue. The reporting officer has recommended a sort of a deferral, which in practical terms means suggesting a non-complying activity status for development and subdivision in the plan change area prior to the Control Gates Bridge being upgraded or added to. Whereas the applicant's position is that that's going too far in terms of constraints, and the appropriate planning response, proportionate and appropriate planning response, is to establish a full discretionary activity status for subdivision and development, which includes a requirement for an ITA, an integrated transport assessment, at the time of any particular development within the plan change area, where you can engage in a very site-specific and targeted assessment of the transportation implications and make a decision as to whether or not some level of development within the plan change area is appropriate prior to the upgrade of the Control Gates Bridge. Bearing in mind that there are, with all of these kinds of resource management decisions, trade-offs. And of course, one of the trade-offs in a discretionary activity assessment of this nature would be what level of additional congestion or delays would be deemed acceptable to this community if it comes with additional housing supply and options in terms of residential land use. And we say that those are resource management judgments that can be made in the context of a full discretionary consent application. And we say that that's an appropriate and proportionate response rather than a very hard-edged non-complying activity status until the bridge is replaced. So again, I think that's probably one of the critical issues that you'll hear more from the experts on.
Just on that matter too, I mean, there was discussion obviously with respect to I guess a threshold of development that might be enabled prior to bringing down the hammer, and 30% was talked about. That's doesn't appear to have gone anywhere in particular, but I'd be interested again in having a conversation in due course with the witnesses on that, because quite clearly from my point of view, one of the options would be to have a lesser activity status for a quantum of development to enable that to proceed before subjecting applicants to a full discretionary application and the implications of all of that. So let me just signal that.
Yeah, well, thank you, sir. I mean, that's a very helpful signal, because really what that idea would entail is potentially another gradation of what's being suggested here. So you might have, as you say, an initial quantum which can be developed within the plan change area with an activity status, and then beyond that you might be into full discretionary, and then beyond that potentially none notified. So I mean, I think that those are all interesting matters that can be explored with the planning witnesses. I can say that the 30% concept that was given some very careful consideration. I mean, I think one of the challenges is, first of all, understanding, well, what is the right threshold? Is it 30%, 20%, 10? I mean, it's difficult. Without an ITA, it's very difficult to actually, it's a bit of a chicken and egg to understand what's the appropriate threshold. So that's one of the complexities of the percentage option. The other complexity, of course, is when you're dealing with multiple land ownership within the plan change area,
who goes first?
Who goes first, and how do you pick a winner, or do you give everyone a percentage of their land? But that doesn't feel like a particularly efficient Resource Management Act response, because what it might mean is a sort of a piecemeal development of the growth cell, depending upon the particular ownership structure of the time. And in resource management terms, that doesn't necessarily deliver an efficient rollout of infrastructure. And so for those sorts of reasons, it was almost deemed that this idea of allocating everyone, say, 30% was probably too challenging. Mm-hmm. And I get to this in my submissions where I say, look, I think ultimately it's the most efficient way to handle this is to simply establish the activity status across the growth cell and then let the projects proceed in the ordinary way, and the ones that gain resource management merit will ultimately come through in terms of the most efficient and appropriate development sequence. So that's ultimately where we ended up in terms of the staging and the sequencing issue. But having said that, I think that there's definitely scope for additional layers within that if the commissioners think that would be appropriate. I mean, I think the fundamental point on this is simply the applicant does not want to see a situation develop where the land is enabled, but there is a single hard infrastructure barrier that effectively gives with one hand and takes with the other, and we're actually no further ahead. And so we're looking for some kind of happy middle ground where we can find a way to continue to add to the supply of residential housing, but in a way that enables the community to determine what's the acceptable level of delay and reduced level of service you're prepared to, as a community, prepared to trade off with in terms of achieving, more residential housing supply. And we think that the structure that we've promoted is the most efficient and effective from in Section 32 terms to achieve that outcome.
Okay. Well, let me just dangle another issue. Well, an allied issue then. I guess the question then is if in actual fact the break point is the control gate and or traffic. I guess the question raised in my mind then, why a discretionary activity? You know what the criteria that need to be satisfied. Why not an RDA? And again, let me just float that.
Well, again, I suppose the first point I would make is that we were responding to a Section 42A report which had a non-comp. Yeah. So we were conscious of where the reporting officer was at. But the short answer to that point, sir, is there is, if we're dealing with what we think is a single issue, fundamentally this is about transportation effects. There is no reason why we couldn't go to restricted discretionary activity status and have everything focused on that one single issue, or however many there might be. Very open to that idea that we shift from discretionary to restricted discretionary. Obviously, the applicant would be supportive of that kind of outcome.
Okay, all right.
At 13, we just talk about the expert conferencing. So there was transportation conferencing that came out immediately following the issuing of the officer's report, where we identified we had this issue with the control gate, and we needed to work through it fairly carefully. So the various traffic experts did get together for some conferencing, and there's I think there was some progress made, but I think fundamentally it hasn't shifted in terms of the position. I think there's a concern on the team of the reporting officers that there is a transportation effect which is unacceptable in terms of levels of service, and they are looking for a mechanism to manage that that particular environmental effect. And it's really just a question of, well, where do we land in terms of what's the proportionate and efficient, most efficient and effective mechanism for resolving the issue, which we all know we've got. At 17, we talk about the amendments to the plan change. And again, I don't think I need to read through those in detail. You will find them at paragraphs 289 to 296 of Ms. Cleary's evidence. So she sets out those amendments in detail. and I've just laid out an account of those amendments in subparagraphs A through I, which are the sort of the headlines of what those amendments are. So with that, I think I can move to what we say are the key issues, or the set of issues that I think are warranting closer examination. The first is this point about heritage and archaeology. So we say there's no archaeological reason why the plan change should not be granted, but there are, however, different opinions on the timing of further investigatory work that's necessary. The applicant's experts consider that this work should be completed before earthworks and subdivision. Heritage New Zealand and the Council's reporting officer consider it should be undertaken prior to the plan change being approved. And we say there's no valid resource management reason for that approach. The applicants have followed an orthodox approach to the assessment of archaeological factors relevant to the proposed plan change. It began with the high-level archaeological review described by Ms. Sykes as an ArcTech, which is a first stage desktop analysis of the site. The New Zealand Archaeology Association's ArchSite was the primary resource in identifying recorded sites in the area, and there was also a site inspection conducted. That report is set out in Appendix K to the plan change and notes that the wider landscape was extensively used prior to 1900 by Māori, and while no specific archaeological risk was identified, it is recommended that further research be undertaken in the form of an archaeological assessment, which would include a site walkover and further research to determine whether an archaeological authority would be required prior to earthworks, or whether works could proceed under the accidental discovery protocol. And then in her evidence, Ms. Sykes confirms that she prepared an archaeological assessment report dated the 7th of September, following discussions with Heritage New Zealand and after consideration of the matters raised in its submission, and undertook a comprehensive site visit on 6 July 2021 and identified some conclusions. I think the critical areas that are being looked at is a couple of depressions that you see in the CN topland, which I think are the only identified areas that all of the experts say are warranting some sort of further investigation. And as I say, the short point for the applicant is that that's a matter that can be appropriately addressed at subdivision and development and earthworks, particularly with an assessment criteria which requires that additional archaeological work to be undertaken. And so it's, as I say, not proportionate in my submission to say that the entire plan change should be held up or even declined because we haven't yet chased down to the nth degree exactly what those depressions might signify from a heritage perspective. But the point is they will be addressed in the fullness of time. Paragraphs 22 and 23 and really through here, I'm just simply setting out and exploring the contrasting position of the experts in terms of the timing. But you'll see at 25, I've set out the rule that Ms. Cleary is recommending and the assessment criteria, which picks up not only the cultural issues in terms of a CIA, which I'll get to shortly, but also any heritage-related matters. So the point is there's a mechanism in the plan change to make sure that these issues are caught and addressed before development actually occurs. There is some quite substantial reply evidence that's been presented by Ms. Sykes, really just to square away what appeared on the face of it to be quite direct criticism of the methodology and the quality of the investigation that was undertaken by the applicant. And while I don't want this plan change to be used as a sort of a platform for archaeologists at 10 paces, I think it was important that we produced a piece of evidence which gave the commissioners comfort that there was actually a quality piece of work undertaken here, and it wasn't thin in any material respect. So that's really the purpose of the fairly substantial reply evidence. But the fundamental point on this issue is that we say, look, the issue is going to be addressed, but it will be caught and addressed at the appropriate time. And there's nothing in the evidence which indicates that there's any reason, any resource management reason why you can't approve the plan change based on the material that the commissioners have in front of you.
Yeah, I mean, I'll just make 2 points just in passing on that. The first is, of course, that if there is an issue, then an authorization will be required. That's a matter of law. And I guess the second point I'd make is that they don't appear to be appearing. And I don't want to make too much of that, but one would have thought that if it was a significant point of difference between the parties, then I would have expected them to appear and actually tell us that. So
yes. Thank you, sir.
Can I just ask a question of clarification at this point, please, Chair?
Yep.
So in amongst all of the information that we have, and there's quite a lot, were there any other parties that raised the archaeological investigations as an issue, or was it just Heritage New Zealand?
Thank you, Commissioner. I understand it was also raised, of course, by the technical expert witness who was supporting the council reporting officer. So you had Heritage New Zealand identifying the issue, and you had effectively a peer review undertaken to support the Section 42A report. But apart from those two examples, I don't understand there to be any party who is raising heritage and archaeological issues of concern. So it's a fairly narrow and confined group that are interested.
Okay, so other than the Walters assessment and Heritage New Zealand, none of the iwi authorities or any of the Māori landowners had raised it as an issue?
I don't believe so, Commissioner. I'll make sure I'll do a scour of the evidence and the submissions to make sure that I'm right. But my understanding of the evidence is that no, in terms of the iwi authorities and the mana whenua interests, there's not been any issue squarely raised dealing with historic heritage matters.
I understand there's an overlay in terms of the CIA stuff that'll come later, but I just wanted to ask that specifically in terms of archaeology. Thank you. That's me, Chair.
Right. So next, moving to the iwi consultation and the cultural impacts issue. The Māori cultural and spiritual values are highly relevant to PC 37, given that it involves Ngāti Tū Wharetoa ancestral land, and in light of the requirements of Section 6E, 7A and 8 of the RMA, and that these factors have been at the forefront of the consultation processes undertaken by the applicants as it's progressed the plan change process. And they have addressed consultation with iwi interests both internal to the plan change area and externally. As a starting point, it needs to be acknowledged that through Council's development of its growth strategy for Taupō, which extends out to 2050, broad and wide community consultation was undertaken, which included mana whenua. Through that consultation process, the plan change area was identified as a land resource which would be subject to urbanisation, and accordingly the broad concept of development of this land has been consulted on in the public domain, including mana whenua, for some time. And can I just say at this point, I mean, I think one of the main themes that is coming through in terms of the submissions and evidence on behalf of mana whenua is not an issue concerning growth and land development. I think there appears to be a sort of a general openness and in fact desire to develop the land and see the land in some way contributing to the urban growth process within Taupō. So it's not as if we come from a position of mana whenua opposition to land development. It's more like, particularly in terms of the mana whenua interests inside the plan change area, it's conditional support subject to certain matters being resolved to their satisfaction. In terms of the specific engagement relating to the plan change, in the period leading up to the lodgement of the plan change, there had been substantial engagement with mana whenua, and that's detailed in Appendix L to the plan change application. And the parties consulted included Te Kūtahitanga o Ngāti Tuwharetoa, Te Arawa River Iwi Trust, Tuwharetoa Māori Trust Board, and Raukawa Charitable Trust as a River Iwi Authority and an Iwi Authority in terms of a statutory acknowledgement. Now, in his evidence, Mr. Crawford details the specific engagements he's had with representatives from each of these entities. He notes that no formal response was received from Te Kūtahitanga Ngāti Tuwharetoa. For Te Arawa River Iwi Trust, he notes that in their letter of comment, they record that they support the direction of the Nukuhau plan change. Tuwharetoa Māori Trust Board acknowledged the plan change and noted that it was primarily interested in the stormwater component and any other parts of the development that might have an effect on Taupō waters. They further noted that they were comfortable that Mr. Crawford was consulting with Mr. Kusabs and Ms. McLaughlin, given their links to local marae. No formal response was received from Raukawa Charitable Trust. As the commissioners are aware, within the plan change area are two blocks of Māori freehold land, the Rangatira 8A17 and Rangatira 8A62B land. Each group of landowners has been extensively consulted in the development and progression of the plan change, and both ownership groups are on the whole supportive of the plan change. In terms of the Rangatira 8A17 block, there has been extensive consultation with its representatives, Mr. Kusabs and Ms. McLaughlin, who, as respected senior identities within mana whenua, have provided the applicants with cultural advice. And in terms of the Rangatira 8A62B blocks, the applicants, through Mr. Crawford, have been in regular engagement with the Land Trust Chair, Ms. Rogers and Mr. Williams, and these representatives have signalled strong support for the plan change and are motivated to progress development on their land. I'm just conscious that there was over the weekend a statement of evidence lodged on behalf of Mr. Kusabs, and there was one particular part of his evidence that caught my eye, and it was the piece of evidence which talks about the conversations and the consultation that he'd had with the applicants, and where he says that in terms of their requests and recommendations, none of them have been followed. And I've asked Mr. Crawford on behalf of the applicant just to respond to that issue and just explain a little bit more around what was asked for and various accommodations and so on, because it's I think probably not quite as stark. The applicant would say it's not quite as stark as the way Mr. Kusabs has phrased it. But nevertheless, we do recognise that the landowners have got their own views on certain matters within the plan change area. There's issues around the medium density location. There's some issues regarding the stormwater alignment down the southwestern edge. So, as I say, I think it can be safely said that while there's general support for the plan change, nevertheless there are a number of live issues that they will want to raise with you. In terms of the consultation with mana whenua outside of the plan change area, there has been direct discussions with representatives of the extensive Rangatira E block of Māori land, which is adjacent to the plan change area. But I think the applicants, by their own admission, would say that the consultation hasn't been easy. There was early engagement in October 2017, which indicated support for the plan change, but this was not borne out in the submission lodged on behalf of Rangatira E, which signalled the plan change would be opposed, as Rangatira E had its own development aspirations that it wished to achieve ahead of PC 37. Off the back of the submission, the applicants then reached out to representatives of Rangatira E, and the meeting was arranged on the 14th of May of this year. But only Mr. Lenehan, an architect engaged by Rangatira E, attended, and no real progress was made. but we say that despite these matters, it's positive to note that the submission and evidence filed on behalf of Rangatira E make it clear that they have no objection to the plan change based on cultural considerations themselves, with their focus firmly on their own land development aspirations and a preference to advance those aspirations potentially ahead of PC 37. And so the applicants are encouraging of further development of the Rangatira E block and have ensured that the structure plan's transport network layout enables connectivity between the two development areas. But just on that point, I think there is a comment in part of the evidence lodged for Rangatira E that the proposed plan change in some way inhibits or doesn't enable development of the Rangatira E land. And that is an issue that we would say is in fact clearly addressed in the structure plan. And there is, in terms of the proposed transport network, there is connectivity that's going to flow through the plan change area up into the Rangatira E land holdings. So it's not as if the urban form can't continue to organically expand out into the Rangatira E land holding, because this plan change in some way sort of creates a ring fence around itself. It's quite the opposite in terms of the transport links, and assuming that infrastructure capacity in terms of wastewater and potable water and stormwater engineering design is sized appropriately to ensure that the area doesn't become a choke point. There's no reason why there can't be this organic extension of the urban form out beyond PC 37 into Rangatira E.
Chair, can I just ask for a quick go back a couple of paragraphs, please?
Yep.
Okay, so and I don't need the answers now. If anything, it's maybe just a flag so you can be prepared. But at paragraph 31, there's reference to a statutory acknowledgement. You with me?
Yes, I am. For some reason, your microphone is a bit fuzzy on my end. I'm not sure if everyone else has experienced it.
Yes.
But I got that. That was paragraph 31 of the submissions and the reference to the statutory authority.
Statutory. Yes.
Dale, you're cutting out. Your mic's cutting out. No.
I'll need to sort this out. Hang on.
That's all right. You're coming through now?
Yeah?
Yeah.
Okay, it might be a battery issue. Sorry, does that sound okay at the moment?
It's better. I can get you.
Okay, so might be just coming through through Kevin's mic. So the reference to the statutory acknowledgement.
You've gone down.
Turn those ones off.
We can actually hear you through without the mic, I think.
How's that?
Yeah, that's fine.
Okay,
Yep.
sorry.
Okay. So in reference to the statutory acknowledgement at paragraph 31, and I'm sorry, it's echoing in my own speakers. So I'd just like some more clarification as to which statutory acknowledgement
Are specifically relevant at some point. Is that okay?
Yeah.
Okay, and
your mic's off, Ms. Modani.
Yes, understood.
And I think I'll just leave that there for now, sort out these sound issues.
Give you a plan, please.
Yeah. Thank you, Chair.
Okay, all right, we'll come back on those matters.
Okay. Just while Commissioner Hunia is there, that question regarding who else had submitted on those archaeological issues, Ms. Thomas has told me that Mr. Jeff Ramaka, submission OS 17.15, and Mr. Thomas Hendricks, OS 18.18. Mr. Ramaka was in opposition. He seeks clarity, and he says I think in his submission that if there is sufficient information, it may be that that would resolve his issue. And Mr. Hendricks is in support. So those were the two other submitters that were interested in that archaeological point.
And just to note that Jeff Ramaka is on the schedule for tomorrow, so we will be hearing from him.
Okay, I think we've got Mr. Hendricks is on there as well, so you can hear from both of them. At 38, we say that overall there's a record of extensive engagement between the applicants and the various iwi interests. Through this engagement, the applicant has identified ways that the plan change can reflect and have regard to the cultural issues identified. That begins with the requirement at the subdivision stage to ensure that cultural effects are addressed through a cultural impact assessment and heritage assessment, which is specific to the development. The robust stormwater management provisions will address those water quality issues identified by Tū Wharetoa Māori Trust Board. Any development within or affecting the Rangatira 8A 17 blocks will be advanced with direct reference to the trustees of that land, which will ensure cultural effects are addressed. This may give rise to specific consent conditions requiring the identification and acknowledgement of areas or features of heritage and cultural significance to tangata whenua. Probably the only point I just want to raise at this juncture relating to the cultural impact assessments is that, and this is a matter that you can address directly with the representatives for Rangatira 8A, is just the point that they've made, and it's come through in much of the consultation and discussions around whether they think a cultural impact assessment is necessary on their land, and whether potentially having a third party or someone come on and potentially attempt to address cultural issues that affect their land is not necessarily something that they endorse. So that was one of the messages that had come through in the discussions and consultation with their representatives. And again, there is obviously the opportunity to test that and understand those sensitivities with the relevant witnesses for the Rangatira 8A group. There is an issue concerning local retail impacts, and it relates to the impact of the proposed neighbourhood centre within the plan change area, and the potential effects on a small local shopping centre at Acacia Bay, the corner of Acacia Bay and Mansell Road. The Rangatira E submission and evidence raised concerns regarding the potential adverse effects on this existing shopping centre, and they assert that there's considerable growth potential for that centre and that it shouldn't be undermined by the plan change. And that same concern is identified in the evidence submitted on behalf of the owners of Rangatira 8A, which also notes that some of the owners of that block have interests in the Acacia Bay Road and Mansell Road centre. And while the officer's report concludes that the proposed neighbourhood shopping centre will not generate any adverse retail distributional effects, the owners of 8A 17 seek expert evidence on that point. And so Mr. Heath, who gave primary evidence for the applicant, mostly in relation to residential supply and demand matters, has provided a short reply statement just addressing the commissioners on this question of potential retail distribution effects associated with the small neighbourhood shopping centre that's proposed. Mr. Heath concludes that with a land area of about 2,500 square metres, you could potentially get a building footprint for a local set of shops of around 1,100 square metres in terms of converting it into GFA, retail GFA. And he says that small convenience centres such as that proposed in PC 37 will accommodate a small cluster of shops. This is commonly your local takeaways, bakery, cafe, liquor store, dairy, convenience services like hairdressers perhaps. These small convenience centre types are evident in all urban areas across the country and are an economically efficient way for delivering frequently required or top-up goods and services to a local community. And ideally, residents are able to walk or drive only a short distance to their local neighbourhood centre. Critically, his conclusions are that the proposed neighbourhood centre would play a different role and function to the larger supermarket-based convenience centres such as Taupō Village and the larger Taupō Town Centre. And in terms of the Mansell and Acacia Bay Road shopping centre, he considers that while that centre might experience some trade competition effects in the short term, these would be quickly offset by the growth in PC37 and the wider Acacia Bay area. And as such, he says that the proposed PC37 neighbourhood centre would not cause adverse trade competition effects to a level that would flow over into any relevant wider retail distribution effects. So again, you can hear from Mr. Heath on that point in detail. Turning to the natural gully network, the evidence lodged by the Regional Council highlights the risks associated with gully erosion and scouring. And while supportive of the further amendments Ms. Cleary has recommended, Regional Council seeks further amendments to satisfy its concerns, and many of those further amendments can be accommodated, and Ms. Cleary has addressed those matters in her reply. The Regional Council also suggests that gully modification should be prevented, and while recognising that gully modification should be exceptional, there should be provision for this to occur, particularly given that it may enable not simply subdivision yield, but also potential restoration and enhancement of the gully network. And in terms of using the gully network for stormwater detention purposes, the region proposes an amendment to the rule, and I've set out the proposed amendment at 46. We say that that wording is inconsistent with the applicant's recommended approach of applying a gully-based detention of stormwater as the final part of a train of stormwater management measures controlling the largest storms. Gully floor detention may also provide a safer alternative to top-of-bank detention where there is significant and increased risk of tomo failure. So while there is acceptance that the gully network should not be the primary detention mechanism, particularly for the purpose of maximising subdivision yield, the applicant's expert, Mr. Bird, concludes that once reasonable peak flow attenuation has been provided on site, suggested 10% AEP for residential and at least 50% AEP for roads, the extra over detention could be provided via the gully storage so that flows to the lower catchment is not increased across all storm events. And he's suggesting that if the council's wording that I've set out at 46 is to be adopted, it really just have an amendment to the second half of the suggested wording from where it says ensure that stormwater is treated on site, to be amended to read that to ensure that stormwater is treated predominantly on site to limit the use of natural gully systems as stormwater reserves. So a subtle change that Ms. Cleary will talk you through and Mr. Bird can talk you through. But as I say, largely we say sufficient to address the issues that have been raised by the Regional Council. There is an issue in terms of the treatment of the Southwestern Stormwater Reserve and how it's to be used and treated within the plan change area. And this is sitting within the Rangatira 8A17 land. And for the landowners, Mr. Greaves has suggested a conversion of the Southwestern Stormwater Reserve to a 3-metre wide landscape buffer, given that its existing topography is not typical of a stormwater gully. Now, Mr. Bird acknowledges that the proposed reserve is not an existing conventional gully like the other proposed stormwater reserves, and as such, it's not proposed due to any of its intrinsic value. However, there are multiple dry gullies within the plan change area that fall southwards towards the existing urban boundary, and most of these gullies stop short of the urban area and rely on soakage for disposal, with the only connection to Council's stormwater system being at Doherty Drive and Northwood Road. This raises the risk of uncontrolled overland flows across the boundary into the housing area during large storm events or hydrophobic conditions. And so what's suggested is that the proposed stormwater reserve creates an overland flow path to divert that excess stormwater away from the existing houses. The flow path reserve needs to be wide enough to convey flow, as well as incorporating amenity planting, and the BAT is associated with cuts through minor high points, noting that a 3 metre width is unlikely to be sufficient for that purpose. And accordingly, we say the provision of a corridor to safely convey that excess runoff is an essential part of the plan change, and the stormwater reserve shown on the structure plan ensures it's reserved for that purpose. Next to this issue of the control gate bridge and the deferred zoning. So at 53, we've identified there's a joint witness statement that's been prepared by Mr. Swears, Ms. Hugh and Mr. Smith. And it's agreed that the control gates bridge is operating at or near capacity, and further development will extend delays and queues at the bridge and adjacent intersection. The roading infrastructure required to service not just PC 37, but also other already zoned land to the north of Waikato River is at capacity or nearly at capacity due to the pinch point of the control gate bridge. Now, the officer's report has recommended deferral of subdivision until there is additional capacity for motor vehicle traffic to cross the Waikato River through either duplication of the existing control gate bridge or a second bridge that provides access to the CBD. And this conclusion is based on Mr. Smith's transportation evaluation, which concludes that any worsening of the performance of the control gate bridge is unacceptable. Mr. Swears identifies that trip generation from PC 37 will exacerbate queuing and delay. However, he notes that it's important to realise that despite its capacity limitations, the control gate bridge is able to carry significant volumes of traffic. And in his opinion, it's unlikely that the queuing and delay increases described in Ms. Hughes' traffic modelling will eventuate, because queuing and delay of this magnitude described will lead to peak spreading occurring. In this respect, Mr. Swears and Ms. Hugh consider that while, if all else is equal, trip generation associated with PC 37 will increase queuing and delays on the existing bridge and associated intersections, it also presents the best opportunity for motor vehicle trips to be reduced through reassigning journeys to active modes and public transport. They consider that PC 37 could be used as a method to mitigate the queuing and delay that will arise as a result of residential development north of the bridge. In other words, if residential development is to occur north of the bridge, better that it occur in this location, which enables these other modes of public mobility. As Mr. Swears considers, if the project is permitted to develop and the total amount of increased traffic is no greater than would occur without the project, the resultant effects would be neutral. However, because of its proximity to the town centre, the project presents the opportunity for traffic volumes and therefore travel time to decrease if motor vehicle trips are replaced by active mode trips. This conclusion appears to be accepted by Mr. Smith, who confirms that the proximity of the PC 37 area relative to the town centre provides an opportunity for relatively high levels of active transport mode share, which would require excellent provisions for these modes, and the plan change could be readily serviced with public transport. But nevertheless, the reporting officer, Mr. Bonis, considers that the potential delays will lead to a reduction in the level of service at the bridge, which is deemed unacceptable. And on this basis, he suggested a rule for deferment of the subdivision. Mr. Smith had suggested a discretionary activity resource consent, with a matter for discretion being the traffic impacts in the vicinity of the river crossing. Mr. Bonis examines the efficiency and effectiveness of 4 options that he's identified in table 2 of his report, being no constraint, discretionary activity status, deferment or decline of the plan change. And Mr. Bonis recommends that PC 37 should be approved with a deferral mechanism. Now, the actual deferment mechanism that he recommends is not a prohibition on development until the bridge is upgraded, but it is a non-complying activity status for development in advance of additional capacity at the bridge. And I've set out his recommended rule at 60. At 61, we say the applicant doesn't support this approach and considers it inferior to the discretionary activity option suggested by Mr. Smith, which is more efficient and effective. And indeed, sir, picking up on your point, it could very well be a targeted, restricted discretionary activity. But put simply, we say that the recommendation option will act as a blunt and unduly prohibitive barrier to development, whereas the option of subdivision having a discretionary activity status and subject to the provisions of an ITA would enable the traffic effects to be assessed at the relevant time and in its specific context. This could present a scenario where, from a consenting perspective, certain transportation delays may be deemed acceptable in the context of the additional housing supply delivered under the proposal. In addition, Mr. Swears and Ms. Hugh have identified and discussed possible development scenarios and the effect on travel times and consequential behavioural changes. The degree to which delay identified in an ITA can be mitigated by supporting behavioural changes such as the provision of walking, cycling and public transport, again, can be assessed as a matter of discretion. These factors could also contribute to a scenario where there could be some level of development which is considered appropriate ahead of the control gate bridge upgrade. More fundamentally, we say the discretionary activity option also avoids the anomaly of a non-complying activity status for residential land use in a residential zone. This kind of land use is clearly anticipated in the zone and it should be reflected in the activity status. As a full discretionary activity, all matters of discretion are available to the decision maker and nothing is gained through a non-complying activity status. And as I say, so by extension, you could say the same thing for a well-crafted restricted discretionary activity status. Finally, on this issue, on the basis that there might be some level of development that could proceed, there's been some consideration given to enabling a staged development so that an identified part or parts of the plan change area could be prioritised for consideration under the discretionary activity status. That consideration has included the potential for each landowner within the plan change area to be entitled to develop up to 30% as a discretionary activity, thereby creating some parity amongst landowners. And as I said in opening, ultimately the staging approach is not the most efficient or effective in Section 32 terms, and it's not being pursued. The most efficient and effective approach is to enable discretionary activity status to all subdivision across the plan change area and allow the merits of any one proposal to be tested in the usual way. Now, I mean, I'm happy to pick up on your point, Sarah, and we'll probably develop this in closing once we've heard all of the evidence, but it may be that there is an early gradation of some development which could enjoy a more permissive activity status and be based on some kind of development threshold. And that's, as I say, that's something that we can explore, and I'm sure it's something that the commissioners could explore with Mr. Swears in particular.
Yeah, well, certainly, I think I mean, the traffic experts need to be thinking through that before they come to us, because I'll be very interested in their views as to where that, I guess, where the critical threshold might be, which could also prove the point with respect to whether any behavioural changes that they optimistically anticipate materialise.
Yes. Well, as I understand the evidence, the behavioural changes are a direct response to additional queuing and waiting time. So
classic congestion thinking. The evidence is a bit light on it, I suspect.
All right. Well, we'll as I say, that's something that you can explore in detail if appropriate with Mr. Swears in particular. Then we go to the reverse sensitivity issue, which Contact Energy has raised, and it's a concern that there will be reverse sensitivity effects in relation to the plan change area at Poihipi Road, which relates to the parcels that are owned by CN Top. And Contact is concerned that where the land is urbanised, the new residents will expect a high level of residential amenity, which may at times be incompatible with Contact's existing and future activities on their land. And to address concerns about reverse sensitivity, Contact seeks that residential development only be able to proceed if there's an encumbrance placed on the titles similar to those which have been placed on the titles to the Taupō Heights subdivision on the opposite side of Wairakei Drive, preventing complaints or objections in relation to the effects of geothermal activities undertaken by Contact, including noise from well drilling, testing, odour, lighting, and effects of other aspects of amenity. Now, the CN Top representatives have confirmed an in-principle agreement to resolve this matter as suggested by Contact, and they're working through the necessary due diligence. Communications with representatives of Contact is ongoing, and it's possible that the matter will be resolved during the hearing, and we will update you. Now, I'm told that Mr. Crawford has got an update for you. There's been further progress made over the weekend. I don't think it's completely landed just yet. I think there's a few aspects of the encumbrance, the detailed wording of the encumbrance, which are being worked through. But I understand the parties are close. Mr. Crawford will be able to update you on that. And of course, if need be, you'll have the opportunity to hear from Mr. Crisp, who I see is on the line.
But in terms of your legal submissions, what's your submission to us in terms of the should we say the legal wisdom of contemplating such mechanisms within a plan change?
Well, I mean, I think that as a starting point, I think it's accepted legal wisdom that as a management technique to address reverse sensitivity, restrictive covenants are not your first go-to option. The better resource management approach is to create a planning environment and a spatial planning environment which simply avoids the effects arising in the first place. And so restrictive covenants of this nature are really an ambulance at the bottom of the cliff resource management response. And so with that in mind, you'd have to say that I think from a planning perspective, you'd seek to avoid the effects to begin with, if possible. Now, the reality in Taupō is that the geothermal elements of this environment, this natural environment being what they are, there is always going to be an intersection between land uses such as residential land use and geothermal energy producing land uses. And Contact is to that extent well established and has a very significant infrastructure investment in and around Taupō that addresses those resources. So we are really in a position where if we could keep them separate, we probably, that would be the preference. But we have, I think, in this case, a scenario which makes those restrictive covenants, in my view, a not unreasonable resource management response. We've got on the one hand the established geothermal resource and the Contact infrastructure and land ownership, which is well established. And on the other, we've got a piece of land which is a very logical and appropriate extension of the urban boundary for Taupō, with a lot of factors which, you know, are mean that it's the right place for residential land use and the extension of residential land use. So you've really got two meritorious resource uses sitting side by side, and we have to find a way for them to exist and coexist. And on that basis, I would say that the restrictive covenant is an appropriate mechanism to manage this potential effect in this circumstance.
You are still seeking to have that, or it is still being sought to have that inside the plan change, not as some sort of side agreement with landowners.
Yes, sorry. So on that point, and I'm sorry, that was I think where the question was also directed. I think the preference is if we can get it resolved as a side agreement and as an arrangement that sits outside of the district plan, that is the preference. And it may be that if that's achieved, that the submission from Contact just simply drops away, and you can get on with establishing an appropriate rule framework for residential use, which doesn't deal with this issue because it's being dealt with externally. So that is certainly the preference, and that's what all the effort is being directed to. And if we have to come back to some kind of plan mechanism, depending upon the way the cards fall with Contact, I'll let you know. But we're trying to take it off the table, quite frankly.
Well, let me signal very clearly that would be my preference. The idea of having a specified encumbrance within a plan change is not something which I'd be terribly keen to go down the track of, but I too recognise that the regional policy, of course, has, I'm assuming, and I think I've read in the planning evidence, that this is a designated regional infrastructure, significant regional infrastructure, and therefore the reverse sensitivity requirements are quite strong.
They are, and that's acknowledged by the applicant.
Yes.
Look, from there, sir, the submissions really just traverse the statutory framework, you'll see, and then we work through some of the Part 2 considerations, if there is necessary recourse to them. Section 77, we've picked up on those matters that are addressed in Section 6, 7 and 8 of Part 2. And I don't think there's any need for me to take you through that. That'll be familiar ground for the commissioners. At paragraph 80, again, we just walk through the policy and planning framework, and there's some discussion on the National Policy Statement for Urban Development. There is understandably reliance and emphasis placed on this National Policy Statement from the applicant perspective. In terms of what it achieves in terms of additional housing supply. I know that there is, I suppose, one point about the National Policy Statement in this area that needs to be carefully picked through, and it's this question of what a well-functioning urban environment looks like in the context of the Control Gate Bridge and some of the issues associated with the pinch point in the transport network. And I think that is a central issue for you as decision makers to work out, well, what in the context of these constraints within the transport network, what level of development can we get away without compromising this concept of a well-functioning urban environment?
Yes, and I have to be very careful not to laud an Auckland response to that particular issue.
Well, that's right, and I mean, I think that is one of the points that that the applicant would make here, is that everything's relative, and what might be considered an unacceptable delay in Taupō might be considered a free-flowing traffic environment in other parts of the country. And these are the kind of trade-offs and the sorts of issues that the community needs to think about. And when it considers, what is acceptable in this environment, if and when it comes with additional housing supply and choice and all of the other benefits that flow from the plan change. So again, a matter that I would encourage the commissioners to be thinking about in that context.
David, if I could just jump in here. Thank you for that, Lachlan. You've actually hit the nail on the head in terms of the local attitude to what is an acceptable sort of delay. And it's, can I just say respectfully, it's quite different to what an Aucklander's response to congestion and delay would be. Yeah, and look, that's understandable. I mean, I think that's not unreasonable, but I think that with change and with development, I think people's expectations around that kind of community amenity need to change as well. And so
the central thrust of the applicant's case on this point is that this community should accept some additional delay as a trade-off in terms of the broader benefits that are delivered through the plan change. And eventually we accept that there may come a time when the community says, look, we need an intervention, and that is a matter for the long-term plan and for the community consultation that occurs once every 3 years, when the council goes out to its community and says, what are our infrastructure priorities? What does the community need? And at some point, the community is going to say, we need another bridge and we need it fast. And that will influence the long-term planning and the infrastructure strategy for the council. But the applicant's position on this is we can't stand still and just do nothing and stymie growth while we wait for that infrastructure intervention. We've got to find a way through, and we've got to find a balance. And the applicant says that it's found that balance for you in terms of its recommended approach. I think really that takes us to the end of the opening submissions. I've covered all of the ground that I really wanted to. We've at 90, we've set out the witnesses that we will call in the order that we'll call them in. The first witness is Mr. Hickman, who is a representative of the applicant group and one of the owners of land within the plan change area, and he's been central to the project. So we'll hear, there's a brief statement that Mr. Hickman wants to read through. It's no more than a page or two, just to show the face and of the developers to the community. And then we simply get into the technical witnesses. So unless there are any other questions, we can, it may be time for a break. I'm not sure, Sue, how you'd like to proceed.
Let me just see if my fellow commissioners have questions. Dale, have you got, do you want to pick any issues up?
Not at this point, Chair.
Okay. Kevin?
No, I'll save them for the technical witnesses. It's probably best put there.
All right, thank you. Well, let's take Mr. Hickman's statement, and then we'll have a break for morning coffee or whatever it is that people need.
Okay, thank you, sir. So I'll just check to see that Mr. Hickman is sitting and waiting. I think he's with, there he is. Hello, Mr. Hickman.
Can you hear me?
We can hear you and we can see you, so that's
excellent.
Good.
Yeah, I'm
Mr. Hickman, you've got a written statement in front of you, don't you?
Yeah.
All right, so I'll just ask you please to, you can pick it up from paragraph 2 and just read from there, if you would please.
Yeah, okay. Good morning, everyone. I am the representative of Lexus Trustee 11, the owner of the property at 48 Acacia Bay Road, which is the block of land within the plan change area identified in Mr. Crawford's evidence as Block F. As Mr. Crawford explained in his evidence, the plan change area consists of a number of separate land parcels involving multiple owners. Within that group of landowners, 3 have joined together as applicants. They are Lexus 11 Trustees Limited at 48 Acacia Bay Road with a land area of 14.55 hectares. AJ Rajasingham LPT Trustees Limited number 124 Limited and Thairu Trustee Company Limited at 24 Acacia Bay Road with a land area of 9.09 hectares. CN Top Investment Limited at 6 Boy Hippie Road with a land area of 22.27 hectares. Today, I'm speaking on behalf of the applicants who collectively are all very pleased to be advancing this proposal, which will enable the supply of much needed housing in Taupo. Through our trustee company, my wife and I purchased our property in November 2016 in the knowledge that while it was a lifestyle block, it was likely to one day be urbanised. We are not developers, and primarily we purchased the property because we love the location. It is a 10-minute walk from our house to the roundabout opposite Countdown Supermarket in town, and a 15-minute walk back up the hill again. The walk to town from our property is via various reserves and footpaths on quiet streets and is a very pleasant short walk that my wife and I make multiple times a week. Excuse me. It is clear to me that the plan change area is well connected to town and an easy stroll or bike ride away from the amenities, shops, restaurants and employment opportunities on offer in Taupo. Shortly after purchasing the property, we were approached by Gloria McLaughlin and Andrew Cusaps, who are the representatives of Rangatira 8A17, one of the other blocks of land within the plan change area. They wanted to talk about a proposed roading configuration through our properties to support the development ambitions. We had numerous meetings and discussions with Gloria and Andrew. The Rangatira 8A17 consultant, David Trewavas, focused primarily on various subdivisional layouts of the 8A17 land and how the roading network would interact with our land. We consulted with Council's development engineer, Roger Stokes, at this time, who encouraged us to consider a more comprehensive approach to potential development, including having Doherty Drive connect to Acacia Bay Road through our land. Once we had a basic agreement with Rangatira 8A17, I approached my northern neighbour, AJ Rajasingham, and then a couple of other meetings with various council staff over the first half of 2017. The signals from council were very positive, and we came away confident that pursuing a residential zoning change was going to be good for Taupo. We approached Hamish Crawford of WSP in August 2017 to help us take this forward. With Hamish, we attended further council meetings and were advised by council that they would be very supportive of a comprehensive structure plan change if we were able to include the CN top land to the north of Poihipi Road. Council advised that they were concerned about the current Poihipi Road, Wairaki Drive, T-junction, and a realignment of Poihipi Road to opposite Hooker Falls Road would be a significant advantage to the proposal. Sorry, on that point in number 10, I incorrectly mentioned roundabout, where it actually is a T-junction, so just wanted to point that out. WSP then invited CN Top to join the plan change and various further meetings with four parties being Rangatira 8A17, CN Top, AJ and Jade Rajasingham and ourselves. For their own reasons, while they signalled ongoing support to the plan change, Rangatira 8A17 opted out of entering into a contract with WSP. And so final contracts were entered into in May 2018. Which firmed up the agreements between the three landowners who make up the applicant group. Despite Rangatira 8A17 opting out, they still remained involved and told us that they would fully support us through the process. They provided cultural advice to us and stated that a cultural impact assessment would not be required. And in fact, it would be something as an insult to them. They also told us that Rangatira E were supportive of the application for the plan change and that Gloria would provide a letter of support from them. It seems that their position was not as I understood it to be. Moving forward, and with COVID arriving on the world stage, time has flown by. The Nukuhau plan change application was submitted in November 2020. Since then, I have had lots of meetings with Hamish Crawford and various council staff members. All the meetings have been very positive, and in more recent months, the benefits of the plan change in terms of addressing the growing housing supply shortage have become more and more obvious. This is hardly surprising. We have an adult daughter recently returned to Taupo, and we understand firsthand how difficult it is for young people to find accommodation either to rent or buy in this town. There seems to be a massive shortage of housing, and we are pleased to be able to provide additional optional for housing with this proposal. Thank you very much for your time. I'd be happy to answer any questions.
Thank you, Mr. Hickman.
Thank you.
Kevin, have you any questions for Mr. Hickman?
It might have been an oversight on my part. The letter you referred to from Gloria McLaughlin, did that materialise?
No. No.
Okay, thanks.
Dale?
No, nothing from me.
Not so much a question, more a I guess a reflection, really. Have you, Mr. Hickman, have you and your group sort of moved beyond the conceptual plan change stage to think about what it means for your individual land holdings and so on, who's going to have the roads and the infrastructure, as opposed to having development blocks and so on? is there any sort of loose agreements or firm agreements about how that might eventuate if a plan change is successful?
No, we haven't.
Okay. Hence your comment that you're not developers, I guess.
Yeah.
Okay. All right. Thank you, Mr. Hickman.
Yeah, thank you very much for your time.
All right. Mr. McLaughlin, I think we'll take Mr. Muldowney, sorry. I'm reverting to 2006 language again. I think yes. I haven't seen Mr. McLaughlin for a long time.
Chair, I've got a small request.
Yes.
When we come back, can we confirm the most up-to-date version of the structure plan? I think I know which one it is, but so that we're all looking at the same one, please.
Yeah, let's do that now. I'm assuming, Mr. Muldowney, that version, I think it's either, is it P or R as the ones that we've most recently seen, although I think R was the latest version that we had in front of us, but we're not sure whether that was, which shows the gully systems on it. Is that the most recent, or do we have another set?
I'm pretty sure it's the attachment to Ms. Cleary's
the reply.
Yeah.
So I'm assuming it's the one dated 1st of 11th.
Can we take the break and I'll just talk to Ms. Cleary and get that absolutely right? I don't want to.
Yep, and just while I'm on it, Chair, just in terms of the, can you hear me all right?
Yeah.
Just to confirm too, along with that plan, that the areas shown on that map referred to in the hashed proposed stormwater reserve with pedestrian access, cycleway and planting, because there's a number of those across it. I'd just like that confirmed that does apply to all of the ones proposed, because I was unsure about the area on the showing on the Rangatira 8A17, whether that was actually proposed. So just something to flag there, some further clarification, please.
Just for me, just for clarity, the map we're referring to, or the structure plan with the date 1st of the 11th is version R, with the notation natural gully system as the last line of text in the key.
Yep, that's the one that I'm assuming that we're operating on. So it's good to have that confirmed after the break. So with that, let's take a 15-minute break. Come back at 5:02, shall we? All right. Thank you.
Thank you.
And just turn your videos and microphones off and just leave them active otherwise. Okay. Good. All right, we're back. Ms. Mardani, can you just confirm the revision version we're supposed to be looking at?
Yes, it's revision R, and it's the attachment to the supplementary statement, the reply statement of Ms. Cleary. So I think Councillor Taylor or Commissioner Taylor had it right in describing it as version R.
All right, thank you very much. That's the 1 November version R.
Yes.
Right. Right, I think we're with Mr. Crawford, I think.
Yes, we are. If with your leave, sir, we'll call Mr. Crawford. See if we can get him up on the screen. There he is. Good morning, Mr. Crawford.
Good morning. I trust you can hear me okay.
Yep, we can hear you and we can see you, so thank you. Mr. Crawford, now you've produced a statement of evidence dated the 20th of October, correct?
Correct.
You have a copy of that in front of you?
I do.
And you just confirm the content of that statement for the commissioners today?
Yes.
Now, you've also prepared a summary statement of that evidence, and which is combined with some short reply comments as well, dated the 5th of November. Do you have that summary and reply statement in front of you?
Yes, I do.
Okay. Can I ask you to please to, I'll just check to see that the commissioners all have that statement available?
Yes. Okay.
Great. So I'll ask you, Mr. Crawford, if you could please just commence reading that summary statement from paragraph 3. And then I also understand that at the end of that, you've got a little bit of an update on the CN top contact matter, and also a brief comment that you wanted to make regarding, I think, one of the briefs of evidence that came in over the weekend. Is that right?
Correct. Yes, thank you.
Okay, so just read the statement and then just add those final 2 comments. Thanks.
Kia ora tātou. So I'm going to set out the iwi consultation steps undertaken on behalf of the applicant. The full account of that consultation can be found at paragraphs 59 to 83 of my statement. As discussed in my statement, 4 of the major landowners within the plan change area were involved in the early discussions that led to our commissioning. Letters were sent to all other plan change area owners and occupiers in January 2019, seeking their contact details and to invite further engagement. Prior to the detail of the plan change getting locked in, we wanted to obtain community engagement at an early stage. To facilitate this, we invited nearby residents to an open day, held over about 5 hours in a meeting room up at the AC Baths. A letter drop was undertaken to nearby residents to invite them to this open day. The open day was very successful. A conservative estimate of 150 to 200 people attended and gave their views. Many of those views were able to be incorporated into the proposal. In regards to mana whenua consultation, we engaged early with Ms. McLaughlin and Mr. Kusabs, who represented Rangatira 8A17. They provided valuable input into the early development of the plan change and associated structure plan. Structure plan reports were provided to 5 iwi authorities on 20 March 2020. At that stage, the plan change proposal had not been drafted, and the purpose of this consultation was to consider and, where appropriate, incorporate any iwi authority views into the proposal. I offered to visit the iwi authorities in person to talk through the material provided, but the earlier arrival of COVID made direct attendance too problematic. I had a number of phone calls and emails with Ms. Nepia of Tūwharetoa Māori Trust Board, who advised on 22 June 2020 that their interest in the plan change was limited to stormwater components and any other part of the development that might have an effect on Taupō waters. Ms. Nepia noted that the trustees of Rangatira 8A17 would no doubt be keeping the local marae well informed. I conversed via email with Ms. Wanako of Te Kotahitanga or Ngāti Tūwharetoa, who requested the plan change document prior to providing feedback. Ms. Wanako was then going to provide the document to local affected hapu. I had a number of emails with Mr. Carlson of Te Arawa River Iwi Trust. Mr. Carlson reinforced the advantage of meeting face-to-face, but again, there was an inability to do so during COVID times. Mr. Carlson was very complimentary on the comprehensive nature of the reports and suggested their primary concern would be around the added pressure on infrastructure, particularly wastewater infrastructure and the sewage pipe going over the river. Mr. Carlson acknowledged this as primarily an issue for Taupō District Council to resolve. Emails to Raukawa Charitable Trust as iwi authority in terms of area of interest and statutory acknowledgement areas, and also Raukawa Charitable Trust as River Iwi Authority were initially missed by them and then discovered in late July 2020. Following the resending of the reports to them, which was acknowledged, no further comments were received. All iwi authorities were emailed the plan change proposal on 12 September 2020. Other than the initial areas of interest identified by Tuwharetoa Māori Trust Board and Te Arawa River Iwi Trust, no further comments were received. I approached the two local marae on 5 July this year. Mr. Belden of Nukuhau Pa advised me that they had no comment at that time. I met with Ms. Walker of Te Rangita Marae on 13 July this year. Now, that wasn't formal engagement. That was for the purpose of me being able to more fully explain the proposal. Ms. Walker raised the matter in 2 or 3 monthly marae committee meetings. I say 2 or 3 because I think there may have been a further committee meeting more recently, and has not yet received direction from the marae committee on this issue. Ms. Walker had thought the outcomes might be to either invite me onto the marae to explain the proposal further, or that they may have enough information to make a decision. I have remained available to continue engagement with them, noting that it is anticipated that marae engagement would continue as the plan change progresses to more detailed development planning. In regards to Rangatira E, my engagement was based on the knowledge that they had no immediate development ambition, which had been the advice to me of Ms. McLaughlin, and also the fact they requested to be removed as a future development area in the 2018 update to the 2005 TD 2050 Urban Growth Management Strategy. Following their submission, I requested a meeting with Mr. Whakwa, who wrote the submission and evidence for Rangatira E, and Mr. Lenihan, architect, who also represented Rangatira E. Only Mr. Lenihan attended the meeting, and he had not been overly involved in the drafting of the submission, which meant he was unable to fully engage in discussions. It is my opinion that the development of PC 37 is a logical first step to allow development of the Rangatira E land beyond the plan change area. Development of land within the plan change area can be designed and controlled to ensure that development of Rangatira E is enabled and facilitated. I do note that any downstream infrastructure, such as sewage pipes, would need to be sized appropriately to include future development on Rangatira E land. And assuming council obtains the necessary approvals, it is my understanding that there is no engineering reason why larger downstream infrastructure could not be achieved to cater for development on Rangatira E land. In reply now to submitters' evidence, I refer firstly to the evidence of Mr. Crisp for Contact Energy. The Memorandum of Understanding, which was discussed in our initial meeting on 10 June 2021, was provided to me on 22 October 2021. So I've been liaising between the relevant landowners, being CN Limited and Mr. Crisp, who represents Contact. Whilst the terms of the Memorandum of Understanding are agreed to in principle by the landowner, they've just been undertaking due diligence on that document, and there's suggested no complaints covenant, as would be expected, as referenced by Mr. Maldani. There's been some updates over the weekend. So yesterday, lawyers for CN Limited forwarded through some suggested relatively minor amendments to the Memorandum of Understanding and the encumbrance documents. So those revisions were forwarded through to Contact Energy yesterday, being Sunday, 7 November, and there was a recognition from Mr. Crisp that they were received, and they're in the process, I understand, of reviewing those suggested amendments by the lawyer for CN Limited. We are hopeful of having the memorandum of understanding signed up, and therefore this entire contact issue resolved prior to the conclusion of this hearing. However, at the time of preparing a statement, and as I stand today, the matter is not yet fully resolved. I'd also like to refer to the evidence of Mr. Kusabs on behalf of the owners of rangatira blocks, generally referred to as 8A17. In particular, point 4.1 notes consultation with myself on at least 2 occasions, and where most, if not all, of his requests were not incorporated into the application. To the best of my knowledge, only 2 requests were not incorporated. So the first of those was there was a request to remove the shops area from the plan change from PC 37. And that was primarily to reduce competition for the shops on Acacia Bay Road. The second thing was Mr. Kusabs requested to move the medium density environment to a location over the land of 8A17. Now, I did not see sufficient merit in either of those proposals. We have adopted their internal road layout into the proposal. We've taken their advice from an early stage in the development, and those are the only 2 issues that I'm aware of that came up at a later stage. That's the end of my summary of evidence. Thank you.
Thank you, Mr. Crawford, and we can obviously pick that up with Mr. Kusabs tomorrow morning. Sorry, Mr. Modani, were you about to instruct your client, were you?
No, only to answer any questions.
Right, sorry about that. Now, I take it, Mr. Crawford, that the intention with respect to the restrictive covenant is to attach those to title?
Correct, yes.
Yeah, all right. So when Mr. Crisp comes before us on the assumption that that matter is agreed over the next 24 hours, then we'll be able to take that off the table. So that's fine. We'll wait to hear from Mr. Crisp on that. Right. Questions? Dale, any questions of Mr. Crawford?
Sorry, Chair, just shifting around multiple documents. Mr. Crawford, I did have a question in relation to the rangatira 8A17 blocks submission, and it's probably one of timing as well. But in terms of the evidence of submitters showing that area of medium density, are you saying that was part of your discussions before and you felt that that proposal didn't have merit? Can you expand upon that?
Yeah, so what we're trying to achieve with the overall plan change is to provide a range of options for that will suit the range of requirements for future owners. So some people, used to be we developed 600 square metre sections. So everyone had a big backyard. As we're tending toward an older demographic, that's not required so much. We're after a range, and so we identified that there is merit in having some higher density, some medium density over the plan change area. Now, there wasn't any reasoning really proposed by 8A17 as to why the land in the south would be more appropriate than the land further to the north. There was, I guess, possibly what you'll hear in the evidence of Mr. Swears is that in terms of trying to get better modal transport, so getting people walking and biking to the shops area, it is better to come from the more northern blocks to avoid Norman Smith Street in particular. So in general, I couldn't see any reason to justify the moving of the medium density further south, and in fact I thought it would be less advantageous to move it down to there.
So just to be clear then, that area that's shown in mine, it's sorry, you won't have the board books reference, but it's an appendices to the submitter's evidence showing that area. That wasn't included in any of the original, either your open days or previous versions in terms of community input, or was it?
It has moved quite a bit since the open days. I think it was probably...
Sorry, I need to be clear. I'm talking about the Rangatira 8A17
it was never
proposal.
shown.
Okay, so it's only come about through this, the evidence from submitters. Is that correct?
They in previous meetings, Mr. Kusabs had requested the so prior to the lodgement of the plan change, Mr. Kusabs and Ms. McLaughlin had requested that the medium density area be located over their land. So it was before the evidence was submitted that I was aware of that request.
Can I just check on that too? Because I had a question which I was going to ask them in due course, but am I correct in saying that, or in my reading, that in actual fact, that was not a matter upon which they submitted? If you go back to their primary submissions,
yes.
Which I did, I couldn't see anywhere in their primary submission where in actual fact they were seeking that. So
I'm sorry.
I just want to clarify that.
I'd need to refer to Mr. Maldoni. I'm not 100% sure at this moment, but I can come back to you on that if you like.
Yeah, well, do, because obviously it's a matter of a reasonably significant matter.
Yeah. Just checking the submissions now, Sue, so we'll come back on that.
Yeah, thank you. Back to you, Dale.
Or maybe while there's a pause, I'll jump in if that's right, Mr. Chair. So, Hamish, just I guess following on from that, just one question in terms of the location of the medium density. What level of agreement amongst the various landowners is there on that, or was this done placed where it is on the basis of that's the best fit, as you've already indicated? Just give some indication of how everyone sits with that.
Yeah, sure. So amongst the applicants who we represent, there was some good agreement with that. As I was mentioning earlier, the areas have changed slightly. So the area of medium density in the northern block, the CN Topland, that did shift slightly further south at the request of Contact Energy. So of course that was to reduce any potential effects on landowners that come about from any potential future operations on their land. So that has reduced slightly further south, moved further south. And I think the shape within the Lexus Trustees 11 land may have changed slightly as well. But overall, right back to the open day stages, those areas of land had been shown as medium density. Those areas were chosen because they're a bit more central into the land. I don't think it'd be appropriate to have them on the outskirts. Usually you'd go from a more intense to a less intense to rural ultimately. So I guess those were the reasons and the background to those.
Yeah, I get that. And in terms of the sea and top land, that's an intra land holding change, but in terms of between the different landowners, is reasonable alignment in terms of where that is, an agreement?
Correct.
Like it was a matter of discussion and they're quite comfortable, yeah?
Yes.
Thank you.
If I can just pick that up, Mr. Court. I mean, I was looking for the planning rationale for the locations and less landowner interest than planning rationale. Are you indicating? I think you were indicating from what you just said that a key determinant of that for you was the, I guess, the transport argument. Can you just run that one back over me again?
Yeah, sure. So I think what you'll see in the bike Taupō submission is that there is concern with some of the biking infrastructure that would come along Acacia Bay Road and probably more importantly through Norman Smith Street.
Yeah.
Now, if you're at the southern portion of the plan change, the logical route would be through that area. Now, the logical route from the areas north, basically from the Lexus Trustees land, so the area immediately above 8A17, I think, you heard from Mr. Hickman's evidence that when they walk to town, they walk through some nice reserve land and some quiet streets and along some footpaths. And that's the logical route to and from town from his location. That would not be the logical route from the land further to the south. And so until such stage as council may upgrade the infrastructure for cycling along Norman Smith Street, it's my opinion that it's probably better to have the more intense areas further north.
And in terms of just in terms of the placement of those ones, and particularly the one in the middle block there off, is it Herapeka Street, isn't it? Have you done some sort of have you done some preliminary master planning as to how the the road networks and so on might operate through there?
We haven't forwarded that through as part of this, but one of the key themes we picked up in the open day was that there was a lot of Herapeka Street residents there, and they were very vocal. And in fact, I think the initial plan showed Herapeka Street continuing on through to the secondary or the proposed secondary collector road. They were quite vocal that they were not in favour of that at all, and so that was one of the many suggestions that we took on from the open day to amend. And so, and I think it's shown in some evidence that the idea is that it would end in a cul-de-sac, so that they're not becoming a through road, and primarily their concerns were around just the use of that road, and it's got some fairly tight bends on it. So there has been some planning done just to check that their requests there can be accommodated, and we can confirm they can be.
All right. Well, we're going to hear transport later. Okay. Okay, back to you, Dale. No, you're good. Okay. All right. Well, for the moment then, Mr. Crawford, I think that's, I guess until we hear from submitters tomorrow, I think we're done with you. Thank you.
Thank you.
Thank you. So we'll now hear from Mr. Tim Heath.
Tim Heath, yeah.
Morning, everyone. Can you hear all right?
Yeah. Morning, Mr. Heath.
Morning, Mr. Heath. Now, you've got a statement of evidence that you'd produced dated 20 October, and you've also prepared a separate reply statement. So just dealing firstly with your statement of evidence on the 20th of October, you confirm the content of that statement of evidence today?
Yes, I do.
And within it, there's a summary of your evidence, which starts at page 6. Would you mind please just reading your summary of the statement before we move to your reply?
Sure, thank you. The current split between residential land capacity areas between the north and south, or south of the bridge and the north of the bridge, is approximately 70-30. That's 70% south, 2% north. While Nukuhau will have some potential to alter that split, the general trend is relatively stable. If the relative competitive nature between north and south of the bridge remains with the introduction of PC37, I would expect to see demand for an additional 140 dwellings north of the bridge over the next 10 years. The upgrading of the capacity of the bridge crossing is a matter of when, not if. In this sense, the economic costs of bringing forward the bridge upgrade must be weighed against the economic and social costs of delay, such as congestion and the increased cost of construction over time. Current and future congestion levels at the bridge, which is at level F during peak times at present, as I understand, is not specific to PC37. It is clear the bridge capacity needs to be upgraded to fully realise the existing zoned capacity north of the bridge. According to recent Stats New Zealand projections, it is expected that Taupō would need to house a further 8,200 households over the next 30 years. In terms of capacity, recent estimates place zone capacity at approximately 5,200, with a further 1,200 provided through current plan changes, of which Nukuhau represents 780. In terms of existing residential capacity north of the bridge, adding capacity in Nukuhau would not automatically generate additional development and therefore demand on network infrastructure such as the bridge. Rather, it will enable choice, and through that choice, a redistribution of development within that capacity. The most economically efficient approach for Taupō District Council to take is accelerate the provision of this critical infrastructure while making adequate provision within P37 for additional residential land supply to come on stream in the meantime. That's the summary of my main or primary statement.
Thank you, Mr. Heath. Now, just turning to your reply statement, you can pick it up, I think, from paragraph 5.
Thank you. This is in relation to discussing trade, competition and distribution effect. In terms of assessing potential retail economic effects under the RMA, there is first a need to differentiate between trade competition effects and flow-on retail distribution effects. By themselves, trade competition effects are not justification for declining a retail consent application under the RMA, or a consent application under the RMA. Excuse me. Unless they are of a level that generates significant adverse flow-on retail distribution effects on the existing centre network of an area. It is within this broader context that the relative merits of the proposed commercial zone within PC37 and the submitter's concerns need to be considered. Trade competition effects focus primarily on the impacts on individual trade competitors. They are direct store-on-store sale impacts on trade competitors. For example, if there is an existing florist in operation and another florist opens in proximity to that store, the existing florist would inevitably lose some custom to the new florist. Case law has established that any such adverse effects are not to be considered for the purposes of the RMA unless they are significant or go beyond what is considered to be normal level of trade competition. Retail distribution effects are generated by and the result of consequential trade competition and retail activity disbenefit effects. These effects can range across the spectrum from positive and negative, depending on the level of effects generated, which are heavily dependent on the scale, type, and location of the proposed activity, among other attributes. As such, it is established case law that council should have regard to significant effects on the amenity of the public caused by any reductions in the viability or vitality of the commercial centres that arise as a consequence of trade competition, i.e. often termed, distribution or consequential effects. Where the pattern of support and retail activity within an existing centre will not change dramatically within the locality as a consequence of a proposed activity, then the retail distribution effects are not considered to be significant.
You can take as read 10 and 11.
Thank you.
Yeah.
Collectively, the decisions in 10 and 11 emphasise and establish that where trade competition produces social and economic effects that are not significant and not beyond the effects ordinarily associated with trade competition, those effects are to be disregarded when assessing an application. Put another way, retail distribution effects occur where a new business or a cluster of businesses affects an existing centre to such a degree that it would erode a centre's viability, causing a decline in its function and amenity, and disenabling the people and communities who rely on those existing or declining centres for their social and economic well-being. Retail distributional effects are differentiated from the effects of trade competition on trade competitors, which are to be disregarded under section 74.3 of the RMA when assessing the plan change. Though retail distribution effects are relevant consideration for a consent authority, it should be noted that the Environment Court case law has made it clear that these effects must be significant, but not necessarily ruinous, before they could properly be regarded as going beyond the effects ordinarily associated with trade competition. It is within this context that the proposed retail effects of PC37 are considered in my subsequent paragraphs. The proposed neighbourhood centre. The proposed neighbourhood centre overlay only encompasses approximately 2,500 square metres of land and is appropriately located from an accessibility and economic performance perspective at one of the main entrances to PC37. This zone land, being central to the wider PC37 development, enables easy accessibility and is positioned to optimise economic performance by being able to service the PC37 market and passing traffic on the Acacia Bay Road. The land area of 2,500 square metres is likely to yield a commercial building footprint of around 1,100 square metres GFA if efficiently developed. This represents a ground level GFA to land ratio of 45%, which based on my experience of assessing small convenience centres around the country for the past 2 decades is an appropriate ratio to adopt. Small convenience centres such as that proposed in PC37 play a different role and function in the market and are subservient to other centres in the network and are scaled to service the needs of its immediate surrounding market, which is the case in PC37. Centres of such limited size draw the vast majority of spend from a localised area and are tenanted by convenience retailers. Convenience retailing can be generally defined as stores used for quick stop or frequently required shopping, used primarily due to their close proximity and easily accessibility to the customer. Neighbourhood centres are typically a small cluster of shops located in residential neighbourhoods. They commonly include your takeaway store, bakery, cafe, liquor store, dairy, and convenience stores and convenience services like hairdressers. These centres provide retail and commercial service needs to the local community and passers-by and are scattered through residential areas. These small convenience centres types are evident in all urban areas across the country and are an economically efficient way of delivering frequently required or top-up goods and services to the local community. Ideally, residents are able to walk or have to drive only a short distance to their local neighbourhood centre. The proposed PC37 neighbourhood centre would play a different role and function to the larger supermarket-based centres such as Taupo Village and the larger Taupo Town Centre. The PC37 neighbourhood centre would have a significantly smaller trade catchment and is not of a scale that would have the propensity to generate any significant diversion of spend away from other centres in Taupo. The nearest similar centre is located on the corner of Mansell and Acacia Bay Roads. This centre may experience some trade competition effects, but these would be quickly offset by growth in PC37 in the wider Acacia Bay area, which will create demand for additional local convenience services. As such, the proposed PC37 neighbourhood centre would not cause adverse trade competition effects to a level that would flow over to wider retail distribution effects in the context of the RMA, particularly given development within PC7 is still a few years away, applying typical development lead times. Happy to answer any questions.
Thank you, Mr. Heath. In your primary statement, you've forecast a 140 dwelling growth in this northern area, or at least demand for that over the next 10 years. I wasn't clear whether that 140 you assumed would come from this plan change area or from other areas which we've been told have been identified for growth but not yet developed yet.
It comes from both.
Comes from both.
The other areas within the Acacia Bay capacity.
I guess I have to ask you what degree of confidence do you put on that number?
Well, we've used the recent consenting patterns across the wider Taupo urban area to look at where the split in demand is occurring at this point in time, or has occurred, and also the fact that I suppose it looks at the existing capacity, residential capacity available both north and south of the bridge to see if those patterns are likely to be maintained moving forward. So I have a level of confidence that that split provides a good guidance. I can't provide matter of fact, I suppose, a portion of...
What's the sort of the error band range that you would be comfortable with saying that's, the upper bound is X and the lower bound is Y?
Yeah, look, I'd be comfortable with the 10% either way.
Right. Okay. And you have a sense in terms of the split that might be apportioned to PC37 as opposed to the rest of the area?
the rest of the northern...
The rest of the northern area?
Yeah. No, I haven't, because I would have thought that it would just get, PC37 would just get put into the north of the bridge pot. And it will literally possibly come down to land prices, dwelling and land price packages and things like that, which will actually be the driving force.
Yeah.
If there is a PC37 gains traction in the market over other areas available in north of the bridge, well, then there'll be a commercial response to that, where land values in other areas will probably drop and balance that proportion up.
Yeah, and just focusing then on the neighbourhood centre, in itself, those sort of numbers wouldn't suggest to me that would make that centre viable in the short term. You have a different view on that?
Yeah, I've assessed the ability for it to be viable on a fully developed fully developed PC37 plus the immediate surrounding neighbourhood area.
Yeah, yeah, right. Okay, yeah, that would be my expectation too.
All of Acacia Bay's market and growth. It's just the immediate catchment.
Right, okay.
Can I just add on to that, Chair, while you're there?
Yep.
So in terms of, you know, obviously the staged approach that we're looking at here, or it's going to be over a significant timeline, how critical is this proposed the shopping area, the neighbourhood shopping centre, in terms of the overall development, given that there's already one in the area?
Well, it's critical in terms of applying and servicing efficiently those fundamental day-to-day goods and services that are required by that community. The greater the distance the community has to travel for those day-to-day goods, the less efficient the network and the more traffic on roads is. So if we can provide those day-to-day goods and services at a localised level, walkable or bikeable or within a short drive, that is the most economically efficient outcome to service that particular market. So I think it's important from an economic perspective, not only PC37, but just for all residential areas around the country to have a little local centre it can access.
So, question from me in relation to that. I get that, I understand it. But in terms of, so I'll just preface this, and I get the competition, and that's not an issue for us necessarily. But in terms of the spatial distancing of these and the quantum of a neighbourhood you'd expect them to service, how close is too close and how many is too many? Or is that too difficult a question?
Well, I'm thinking of a market that's going to be a lot more developed than what it is at present. So if you add the 780, I think, of PC37, and then you add all the capacity, the zone capacity of Acacia Bay within the total north of the bridge market, there is more than sufficient to support both centres. How close is too close? That's often driven by the network itself and the market. These centres prefer and perform better if they're not internalised on local roads. They tend to perform better where they can have access or tap into markets on more arterial roads. So it can service both. In this location it does, and also the Acacia Bay Centre, existing Acacia Bay Road Centre does that as well. So look, I've seen centres of this scale and type within a couple of kilometres of each other, and I'm not talking Auckland, I'm talking in other urban areas around the country, and they work successfully. So there is no magic distance rule, but I'm comfortable with the distance between the PC37 Centre and the Acacia Bay Road Centre at the moment as fine, long term.
And Mr. Heath, if you could just confirm then, what is that approximate distance between the current shopping area and the proposed?
I haven't got it off the top of my head. I think it's about a kilometre and a half.
Yeah, I measured it at about a kilometre. Yeah. So, Mr. Heath, would you see any merit in deferring the ability of that centre to establish until such time as a certain proportion of the plan change area had developed, to prevent it becoming too competitive with the existing Rangatira shopping centre?
Yes, I'm not uncomfortable with that proposition, and that, to be honest, that's what normally happens anyway. The centre wouldn't develop until there was material development of PC37, because that is its core market. And of course, if your core market's not there, then you're unlikely to get retailers go there either. And sometimes these centres can be staged, but this is of a scale that probably staging would be a little bit tough on them. It's only 1,000 odd square metres. So the market by itself will likely manage any staging in that process, but I wouldn't be uncomfortable with having a certain maybe residential threshold that gets achieved before the centre can really kick off.
Yeah. All right. Thank you. Any other questions for Mr. Heath?
So just one more from me, David. Just again, centres on location, and I get it that it's next to a medium density zone. What, if any, consideration was given to putting it further away next to the more northern medium density zone? And given you've got a large area completely unserviced, again, outside of this proposed plan change, but on the eastern side of Wairake Drive, you've got that, potential catchment for customers there.
I wasn't part of the development of the structure plan per se. The location, or the proposed location of the centre, was already in the structure plan when I got involved, and my role was to provide, if I could, that the level of comfort around that particular location, and I can support that location over the vast majority of other potential areas of that centre zone within PC37. From an economic perspective, that would be the best location for it. Basically, one of the key entrances in and out of PC37, so you capture all of that market, and some of the passing traffic as well.
So better than further north and east towards the northern medium density zone. Is that what I'm hearing?
I'm comfortable with its current location where it is at the moment.
Thank you.
All right. Thank you, Mr. Heath.
Thank you.
Thank you, Mr. Heath. We now call Ian Gray on geotech matters.
Oh, good morning, all. Have you got me loud and clear?
We have.
Certainly loud, yes.
Sorry, I'll calm it down.
Yes, too enthusiastic by far. Yes.
You never know with these things. I will just hook into my summary of evidence, which starts at number 6. A site walkover of 5 of the 6 sites was undertaken on 21st of February 2019 by members of WSP to identify any geomorphic features that may have an impact on the development proposal. Site 5 could not be accessed, but visual observations were made from adjacent sites where possible. I think, as your team saw, it was heavily vegetated at present. Following the site walkover, a comprehensive written report was prepared dated 27th of October 2020, which addressed all relevant geotechnical issues, and I have reviewed that report. The report is set out at Appendix I to the plan change application documents. In order to meet the requirements of New Zealand Standard 4404/2010, Land Development and Subdivision Infrastructure, and the Taupō District Council Code of Practice for the Development of Land for Subdivision of Existing Lots, I recommend the following. Excuse me. Further detailed geotechnical investigations with accompanying subsurface investigations should be undertaken prior to each stage of subdivision development to inform detailed civil design and to identify areas of loose near-surface soils, such as that encountered in Borehole 4, which was the CN top site, most northern block. Shallow NZS 3604 2011 type geotechnical investigations should ultimately be undertaken on each lot prior to application for building consent to ascertain whether individual lots are able to be designed using the proprietary designs from that standard or whether specific engineering design is required. Existing stormwater flow paths and gullies should be maintained where possible to avoid stormwater concentration in one area and reduce the chance of tomo formation. Requirements in the detailed stormwater report will supersede the requirements of this report on this section. There is a crossover between geotech and stormwater in these aspects. Dwellings should be provisionally offset at least 10 metres from any steep-sided gullies, such as the Brentwood Gully extension and the stormwater infiltration basins in the CN topland, in order to reduce the risk to dwellings from potential slope instability. It should be noted that subsequent detailed civil design may overrule this requirement if the landform is ultimately sufficiently modified and/or retained. Construction should be avoided on any areas of historic or uncontrolled fill, including the fill found on the Rejassingam site. Further investigation or removal of this fill is recommended prior to housing development in any areas of uncontrolled fill. Further investigation should be undertaken in the area surrounding CPT 02, the Rejassingam site, to determine the presence and extent of a possible large tomo at 15 metres depth and its impact on future development. Geophysical investigations are recommended in this location to help to define the extent of the affected area. No construction is recommended in this area until the exact extent of this feature has been investigated and assessed. Construction should be avoided within any fault avoidance areas, including that of the fault identified in the northwestern corner of 27 Watene Lane, Rangatira 8A6B2. Further investigation into groundwater levels across the site by installing and monitoring piezometers prior to subdivision. These would be particularly useful in the localised areas where potential perched groundwater has been identified. The investigation points are discrete points and have been generalised to provide a geotechnical model for analysis. However, it should be noted that perched groundwater may exist at locations within the site that were not investigated. The depth to groundwater is uncertain across the block as a whole. The groundwater depth will significantly influence liquefaction potential. In the event that shallow groundwater levels are identified and the probability of liquefaction increases from low, which groundwater at depths greater than 15 metres, to high to very high, where elevated or perched groundwater levels exist, measures such as those recommended in Canterbury guidelines can be utilised to mitigate any risk to residential structures. Further liquefaction analysis at the civil design stage when final ground levels are known, as this will affect the amount of settlement experienced at each site during seismic events. Number 9, the proposed plan change area sits within the Wairaku Tauhara geothermal field, which is subject to a number of areas of subsidence due to geothermal drawdown. Information was sought from Contact Energy regarding settlement due to geothermal power development in the Nukuhau area in particular. The information provided indicates that this area is not within a known subsidence bowl and had not experienced significant settlement during the last area-wide survey in February 2017. In conclusion, based on the above information, I consider that all sites within the PC37 area would be generally suitable for residential development from a geotechnical perspective. Observed areas of immediate concern have been highlighted and will need to be addressed during the civil design stage at the time of subdivision. It should be noted that due to the nature of the assessment, further unsuitable areas and or soils may be encountered during subdivision development, and consideration should be given to this during the civil design stage. Thank you.
Thank you, Mr. Gray. Just go to questions. Kevin, any questions?
Just one, going back to the uncompacted fill, or the natural ground there. What sort of depth are we talking about there, Ian?
I cannot recall. I'd have to get back to you on that. And in general, this is a very large block that we're looking at, and pastoral activities have occurred down on site number 6. That's a ex-forestry block. The issue may hit us anywhere, so it's not so much an issue from a global perspective. It just needs to be dealt with at the time where it's found. Has been a farming block. You can find all sorts of things. So I don't know off the top of my head, and I can get back to you on the depth it was found.
That's why it's paragraph E I'm looking at, and just the next one in paragraph F, where you've got the extent of a possible large tomo. Was that through sounding? I don't go too deep into the technical stuff of that, but possible or confirmed?
No, in essence, it was confirmed. So that was when we're doing a borehole, they drilled, and then they actually finished at 15 metres, and then they lowered down to try and find groundwater, and then their tape carried on down to 30 metres. Now it is very unusual to find something like that. I have found very significant tomos in the district, but that is something that is unusual, and it needs to now be looked at with geophysical measures. Boreholes and CPTs are discrete. For something like this, we have to understand if it's a little chimney, for want of a better term, or whether it's a dome structure or what it is. So again, it is a significant feature, and it may yet determine yield in that area. We may determine we can't do anything with it, and it may not be suitable for residential, or we may be able to fill it in or do something like that with it. But it is significant, and it needs to be looked at and determined what to do with at a later date.
Sure. So if it was a dome-shaped cavity, that the extent of that could be quite significant.
Yeah, it potentially could be, yes. Again, I mean, I'm grasping at straws. I haven't seen anything that significant before, but that leads me to believe we have very large residential areas surrounding us, so it's unlikely that there's something random like that sitting there. I would like to think that it is more constrained, but only a geophysical survey is the best way to determine that, and that will need to be done, and from that, appropriate measures taken.
Thank you. That's all from me, David.
Dale, are you there?
Nothing from me, thank you.
Okay. General question. Mr. Gray, you've looked at the provisions that are being recommended. Are you satisfied that they're sufficient in terms of, for example, your very strong statement in subparagraph F there that no construction should occur? Does that require a provision, do you think? And is there a provision in the plan change currently that reflects that recommendation?
I'd probably have to bounce that one back to Mr. Maldoni. I mean, from the geotechnical perspective, for a plan change, we're looking at large issues that can't be overcome or are very complex to overcome. We haven't really seen any of that in here. So to me, it's smaller issues that can be dealt with on a case-by-case basis as they come up within an individual subdivision. So
you don't think there's a need for a provision, even as an assessment criterion, for example?
Can you, I'm not sure I fully understand the question.
Well, I guess one of the options that you have in terms of putting a plan change together is where there are uncertainties to actually a provision that requires that formally to be ticked off, if you like, or made certain before you actually proceed. Accept the fact that for subdivision consent and so on, that you're going to look at certain ground conditions and establish an actual fact that you've got a viable platform that you can build on. That goes without saying. You seem to be saying something a little bit more concrete in that one. So it's just a question as to whether you think that requires something a little bit more concrete.
No, I mean, I don't see anything here that is so significant as would require that. I certainly think the anomaly where we have a cavity at 15 metres depth, that is a very interesting feature. I don't think we necessarily need to put something in to address that. That ultimately, again, I don't know what that is. It is a significant feature, but I think it doesn't affect the land or the plan change as a whole. If it was found to be insurmountable, it would simply reduce the yield of that area in particular.
Yep. So I'm really picking up in your 8A as well, where you're saying that further detailed investigation should be undertaken. And you've used the term there, prior to each stage of subdivision. Formally, we don't have a staged proposal in front of us. Annual B covers each individual lot. So again, are you suggesting that there should be something prior to allowing some of these larger lots, for example, to proceed? Or what are you thinking of when you say prior to each stage?
I'll try and explain it as best I can, because it may, in my mind, it kind of tangles itself up for whichever lot or whichever block would go first. We have talked about maybe it's 30% of this can go early, because it may be, I don't have a good feel for whether or not every landowner gets 30%. In that case, to accelerate that, or if it's a block which is 30% and then you accelerate that. I'm also aware, and this is where I think deferring it to a later date, or much of this, say the liquefaction aspect that we're looking at, the district's subject to very large scale liquefaction mapping and stuff at the moment, where we're just stepping through with WRC. And that environment may well change prior to a subdivision consent coming in, should the plan change be approved now. So there's no point in doing that piece of work now if we're in a slightly different liquefaction environment or understanding in 5 or 10 years' time. So I don't know that that answers you completely, but
no, I mean, I understand the reservation on that one. I guess I'm just thinking we don't know the scale of subdivision that might take place. It might be very small subdivisions. It might be 5 lots, sort of real, at the bottom end of what might be feasible as a viable development. And the problem with that, of course, is that if you're looking for a slightly wider assessment, a geotech assessment, you may not get that through a series of very small lot developments. So you won't build the picture, and potentially won't build the picture until it's too late. So I'm just wondering whether in actual fact, again, and to some extent, the questions I'm asking you are really just going through you to the planners who will need to respond in due course on that. But it really is a question as to whether is this something that we can take the risk of a small lot by small lot proposition coming forward, or is it something that we need to do more on a broader canvas to prevent that?
Yeah, and I think I could probably, again, just knowing what the industry is doing in the background, say if it is very small lots, or maybe it's 5 or 10 lot ones that come through, there aren't big onerous issues on the site. We don't have global instability. Some of the big geohazards that we're trying to understand at this end, we're not really seeing that here. So probably the biggie that jumps out is whether or not there is liquefaction potential on some of these. Now, you go to somewhere like a Canterbury and they're actually doing a liquefaction assessment on each house site in many cases. So that may well come quite easily into our planning here, and that if it's a 5 lot subdivision, maybe that is something that needs to be done in the near future anyway. So we're not seeing big global geohazards on the site. So much of it actually probably can be done, or that's where we're comfortable at being done at the subdivision stage. And it probably doesn't matter if those are relatively small lots. Yes, it does sit on the developers at that point, but the property doesn't have very big, scary geohazards. We do have things like the fault rupture zone up in that southwestern corner, but again, they're well understood fault rupture and offsets and things. So they're not, nothing's jumping out and biting us here that can't be undertaken on a much smaller scale, in my opinion.
Okay, good. And the only other question I have is because I don't know what Contact have been doing in recent years. Is there any reinjection going on in this general area?
Again, I'm not 100% sure. I'd have to get back to you on that. I outside of my field, I'm not sure.
Yeah, all right. Well, maybe Mr. Crisp can advise us on that tomorrow when he comes. He can find that out overnight. Just a question as to whether reinjection might itself create some boundary issues. Yeah. All right.
Sorry, David, just one other question that dialogue just raises. A couple of quick questions from me, if you don't mind. So, Ian, just so I'm clear in my mind, 15 metres down and then another 15 metres gap, not sure what that is, whether it, in your words, a chimney or a dome-shaped structure. And I hear your comment regarding liquefaction risk. Does that depth of Tomo or whatever it is create any collapse risk, or is that too deep to be a risk? And my second question is, having identified one there, what is the potential for that on other areas within the plan change?
Some nice curly questions. Again, a lot of work would need to be done to determine it. If there's a 15-metre void sitting there, it's unlikely that you develop at the top, even though a 15-metre dome structure over the top of that is probably going to bridge. Your loads would never get down there. But having said that, it's kind of like your limestone areas where you have big voids. Unlikely your loads would collapse it, but again, professionally, you'd want to do a whole lot of work if you were going to propose to go on top of it, without doing any work and leaving a void there. The geophysical survey will tell us if it's this beautiful dome structure, if it's nothing, if it's just a random thing. So yeah, a lot of work. I mean, when we got there, it raises alarm bells in so much as it's something a little bit unusual, and it is a significant feature. So we can't hide from that. The chance of structures being like that further, and Mr. Bird can potentially come into this because this is where geotech and stormwater get tangled up. There's little tomos all over the property. We're aware of tomos further down the catchment. I've done work all over the district for nigh on 17 years and I've never seen anything this large, so that leads me to believe it's probably quite an isolated, random type structure. We can't definitively determine that there are not other structures like that, but it's unlikely.
Great, thanks. Well, I'm just still picking up, David, what you're saying is, how do we address this, or do we kick it down the road, which doesn't seem to me to be a particularly viable option anyway.
All right. Thank you, Mr. Gray.
Thank you.
Thank you, Sir. Can I just also, just on that last point, in terms of the rules, there is subdivision rule 4A817, which has some existing provisions which would apply, presumably on the basis that this is not a new issue in and around Taupō. And there is subsection B, which talks about assessment of whether the design and layout of the subdivision avoids, remedies and mitigates any adverse effects resulting from identified natural hazards, which could include geohazards. Mm-hmm. So it gets caught there, and it also gets caught in subparagraph G, which talks about residential development being assessed in terms of the appropriate of the design, layout and density of the subdivision having particular regard to geotechnical and topographical considerations, including potential liquefaction effects for subdivision. That's in a particular part of the district. But the point is that there's provisions that exist within the plan which would be brought across in terms of this plan change area, which appear to capture the considerations at subdivision stage. Whether there's a need to do something bespoke for this plan change area is a matter that obviously can be explored with the planners, particularly that point about whether it's appropriate to deal with it on a piece-by-piece basis, or whether there should be some sort of broad and overall assessment undertaken at the first subdivision stage, which covers the plan change area, or at least big sections of the plan change area. But that might be a matter for the planners.
Thank you for that. Yeah, no, I was certainly aware that these issues are not novel to Taupo. Yeah.
Thank you, Mr. Gray. So now I'll call Mr. Bird on Three Waters, please. Good. Still morning, Mr. Bird. Good morning.
Yeah.
Thanks for being here. Now, Mr. Bird, you've got a summary statement section in your primary evidence dated the 20th of October, and you've also got a reply statement. So we'll start firstly with your written statement of 20 October and ask you just firstly to confirm the full content of that statement.
Yes, thanks, Mr. Mulvaney.
Yeah. And then you can you can simply read the summary of that statement.
Yeah. I'm responsible for preparing evidence in relation to Three Waters and have, so I would like to just perhaps start with a summary of evidence of that Three Waters statement, perhaps picking up at my paragraph 12. Where I just run through the Three Waters respectively and talk about how they're going to be addressed. Paragraph 12 says potable water can be obtained from the Taupō Township supply, but a pump station and pipes will need to be upgraded to ensure sufficient pressure is maintained. 13, wastewater from Nukuhau development can be discharged by gravity into the Taupō Township reticulation once capacity limitations in the existing system are addressed. The required work is already on Taupō District Council's work program. Until that time, Nukuhau discharge should occur. No Nukuhau discharge should occur unless other arrangements have been made. So in respect of water and wastewater, essentially I'm saying we simply need to spend the money and the problems can be managed. Stormwater disposal will be primarily to ground soakage after first being treated where it arises from roads. Excess flow in large storms that is greater than 10% AEP will flow as overland flow to existing natural gullies, which will be retained and enhanced to convey flow without causing erosion.
Thank you. And then to your reply statement.
And if I move to my reply statement, where would you like us to pick that up?
I think probably paragraph 3, where you talk about you start with the gully modification.
Sure, yeah. Okay, so the statement is largely in response to the evidence of various submitters. Paragraph 3, Waikato Regional Council and others have submitted that gully modification should be prevented, full stop. My own view is that if primary gully and significant flow path modification is ultimately proposed, careful investigation, planning, and design would need to occur to inform such a decision. This would rely on close attention to all relevant site factors and include meticulous execution. I acknowledge that the bar for any gully modification proposal is likely to be very high, and modification will always be the exception rather than the norm. Ms. Craven, on behalf of Waikato Regional Council, considers that hazards or constraints are already well understood at a high level. Ms. Craven and I are likely to agree on these high-level factors. However, I consider it would be premature to outlaw gully modification without full consideration of specific site factors. Moreover, gully modification should not be narrowly interpreted to mean gully relocation to maximise subdivisional yield. In fact, gully modification could take the form of certain desirable activities like restoration and enhancement. Paragraph 7, use of the gullies for stormwater management. Ms. Craven proposes that following addition to Rule 4A7, Nukuhau Structure Plan Area, which reads, the management of stormwater in accordance with the Waikato Regional Council Stormwater Management Guidelines 2020-07, and to ensure that stormwater is treated on site to control the use of existing natural gully systems as stormwater reserves. I agree with the first phrase, but consider the second part needs revision. In other words, no question about accepting the stormwater management guidelines, but my comment relates to the second part. As proposed, it could be interpreted to prevent any stormwater management being undertaken in the gullies, which is contrary to the approach outlined in my primary evidence and in the application. I proposed that gully-based detention could be a final part of a train of stormwater management measures controlling the largest storms. Gully floor detention may also provide a safer alternative to top-of-bank detention where there is a significant and increased risk of tomo failure. Ms. Craven and I are agreed that gullies should not be the first choice option for stormwater management, for management of routine storms. Her quote, gullies should be left in their natural state where possible and not be considered a major stormwater devices in the first instance. It is not appropriate to use gullies for stormwater management simply to maximise the residential yield elsewhere. However, once reasonable peak flow attenuation has been provided on site, I suggest at least 10% AEP for residential and at least 50% for roads, the extra over detention could be provided via gully storage so that flow to the lower catchment is not increased across all storm events. Accordingly, I propose the following modification to Ms. Craven's wording, amendment shown in strike through and underline. So my suggestion, and I'll just read the proposed new version, and to ensure that stormwater is treated predominantly on site to limit rather than control the use of natural gully systems as stormwater reserves. Just to say that's slightly more permissive, but still retaining a high level of control. Paragraph 11, stormwater impacts on neighbours. Mr. Farquhar, in his evidence for the Rangatira E Trust, cites a case where a downstream property has, through development, become sensitive to the unaltered stormwater discharges from the trust land upstream and expresses fear that something similar could happen with the PC 37 development, where I note the trust also owns land immediately upstream of the PC 37 area. Reverse sensitivity may arise with any development, but the case described appears to be more one of poor engineering than reverse sensitivity. Mr. Farquhar suggests that an overall strategy or catchment management plan is needed to avoid issues like this. I disagree. A holistic catchment management plan may be helpful for other reasons, but boundary issues like that described can be avoided by sound engineering. The most significant flow paths from the trust's land into the Nukuhau structure plan area have already been identified and provided for in stormwater reserves / natural gullies shown on the structure plan. But all other drainage features crossing the boundary will also need to be assessed and provided for. This is a normal part of development engineering. Paragraph 14. Southwestern Stormwater Reserve versus landscaping strip. Mr. Farquhar's concerns provide an appropriate context for consideration of Mr. Greaves' argument for conversion of the Southwestern Stormwater Reserve, identified on the Nukuhau structure plan, to a 3-metre wide landscape buffer. I acknowledge Mr. Greaves' point that the proposed reserve is not an existing conventional gully like the other proposed stormwater reserves, but as such, it is not proposed, and as such, is not proposed due to any intrinsic value. However, I believe Mr. Greaves has misunderstood the purpose of the proposed stormwater reserve. Multiple dry gullies within the owner's land fall southwards towards the urban boundary. And I just point you at this point to an image I put on the next page of my evidence. You may like to just look at that as I continue reading.
Thank you. Yeah.
Most of these gullies stop short of the urban area and rely on soakage for disposal, the only connection to council stormwater system being at Dockedy Drive and Northwood Road. This raises the risk of uncontrolled overflow across the boundary into the housing area during large storm events or hydrophobic conditions, the very problem reported by Mr. Fakwa a few streets away. So just looking at that diagram, you can see those gullies, southward-facing gullies. You can see a diagonal property boundary running along to the southeast, and you can see the major gully in the southeast, on the eastern side. So we're proposing a stormwater reserve along that diagonal gully to deflect that flow into the main gully and prevent the possibility of it flooding the housing area. Paragraph 15, the boundary line falls more or less steady towards the main gully, presenting an ideal opportunity to create an overland flow path to divert excess stormwater flows away from the existing houses. The flow path reserve needs to be wide enough to convey flow, as well as incorporating amenity planting and the batters associated with cuts through the minor high points. A 3-metre width is unlikely to be sufficient for this purpose. I believe an overland flow path is essential to responsible engineering design. However, in partial concession to Mr. Greaves, I also note the gullies concerned are mostly contained with the owner's land portfolio. That's owners plural. And some are small-scale features that might, following proper assessment, be candidates for filling. It is within the power of the owners to make alternative provision for overland flow paths, perhaps in conjunction with subdivisional roads or reserves elsewhere in their development area. In summary, I consider the provision of a corridor to safely convey excess runoff is an essential aspect of responsible development in this area. The stormwater reserve shown on the structure plan ensures the land is reserved for this, that land is preserved for this purpose. However, it is not essential that this flow path is aligned along the southwestern boundary, although it is the most logical. There is sufficient flexibility within the processes that follow to allow that corridor to be relocated if there is engineering justification to do so. Yeah, thank you very much.
Thank you, Mr. Bird. Let's turn to Dale. Have you any questions for Mr. Bird?
Mr. Bird, this might be better directed at the planning evidence, but just while I have you, particularly with that picture that you outline, at page 5 of your evidence showing the flow path, can you, what do you think from the perspective of a staged approach, which may be a result of if this plan change was to go through, how critical is the overall approach to managing the stormwater as opposed to, I guess what I'm getting at is I'd like to understand what you see as the risks of a kind of a piecemeal or staged approach by land tenure rather than a overall view of management from the gullies. So you mentioned, for example, that on this area they may infill areas as part of their subdivision. What are the risks associated with that approach as opposed to, say, particularly in terms of the gullies, planning for that now before subdivision?
Yeah, clearly I acknowledge there are some risks. The risks are less if development proceeds from downstream to upstream. But if for some reason an isolated lot were to want to develop, then there would need to be continuity of the stormwater management. And I guess by that I mean whether the pipe or the overland flow path or the system is entirely built. I mean, there may be scope for doing interim works rather than putting a pipe in, it might be sufficient to simply make provision via a surface channel through the downstream land. But there would need to be that provision in some fashion so that there is continuity of provision for stormwater from the source right through to a safe disposal point.
So are you saying that that is possible as part of a, at the moment there is no preferential staging?
Yes, I am saying it's possible. It would require cooperation from the developers who, I believe, all essentially, want the same thing. They're all in planning to develop in due course. And so the staging that you were describing, it should be possible to make suitable arrangements.
Kevin?
But there is, I should probably also just say, there is an outside scenario that if that cooperation is not forthcoming, it might become a block, a barrier to some of those upstream owners developing.
Sorry, can you expand on that a bit as a scenario? Because you'd sort of, I'm interested at where you've said, ideally you'd go from downstream to upstream. Is that in terms of managing the flow of water outside of the boundaries?
Yeah, what I'm saying is if you start at the downstream end, then that developer would provide, let's say, the overland flow path through his property that would link at his upstream boundary to the next one. If he does not develop first, then that flow path will not be there, and some sort of interim arrangement would be needed to allow the upstream developer to proceed. Now, expanding on that scenario, if that downstream developer is uncooperative and is not willing to provide either temporary or permanent flow path across his land, then the upstream owner would not. Yeah, I'm saying there's a high likelihood that his development would be blocked. Because
I'll push pause on that for now.
Yeah, I mean, typically, in a comprehensive plan change, you would have a stormwater management plan that covered the entire development, and subdivision applications would be required then to line themselves up with that comprehensive stormwater management plan. I'm not sure that's required in the provisions that currently stand, is it? Can you just remind me, Mr. Bird?
No, there is no requirement currently for a comprehensive stormwater management plan. A stormwater report has been prepared as part of the application material, but it doesn't go to the sort of depth that would address this issue.
Would you see that as being advisable?
I would see it as being optional, but certainly if there is a risk of property owners not being able to cooperate sufficiently, then that would be one way of addressing that uncertainty, that risk.
I mean, the problem that is foreshadowed there, of course, is that by the time it becomes evident that the developers can't work together or the landowners can't work together, it's too late to actually put something in the plan.
Yep,
I guess the question is whether or not there is merit to belt and brace that issue so that in actual fact the risk of non-cooperation is not an issue.
Yeah, certainly what you described would be one mechanism for managing that risk, yes. It would be an effective mechanism. And
I mean, you would agree, I presume, that given that stormwater is likely to be a pretty fundamental issue to the development of these blocks of land, that one would not want to court that particular risk.
Yeah, I just remind you that it currently, the structure plan does provide for, in this area we're focusing on, it does provide for a stormwater reserve through the downstream properties. So it really does set out quite clearly the intention that a corridor is to be made available for overland stormwater flow.
Yes, I guess I'm also thinking about you've left the door open in terms of other options, of course, by indicating that your sort of transverse interception device through the boundary with the developed area may not actually be required because there may be some alternatives that come through the development options.
Sorry, carry on.
No, I'm just sort of open musing here as to whether or not, if you allow those sort of options to come forward, whether one might get into one of your sort of upstream downstream problems in actual fact.
Yeah.
I don't know. I need to think through the issue. As I say, normally when doing plan changes like this, one would expect there to be a more formal stormwater management requirement of a block of this size. But yeah, I'll think more in terms of I guess where you've currently ended up with your options in terms of that. Unfortunately, I wasn't able to walk the ground and look at those gullies, but I did indicate to my colleagues that it was an issue which I had some concern about. But anyway, we'll leave that one for the moment. Kevin, do you have any questions for Mr. Bird?
No, I'm just reflecting on our walkover yesterday, and I'm just talking to Dale regarding that 3 metre offset from the developed land already, and just picturing that in my mind. So having walked the gullies, I can see where there is natural flow paths into part of which is a very steep and deep gully. But I'm also conscious that where it terminates at Acacia Bay Road, which I'd have to say was a bit of a surprise to me, there's no culvert. It just stops dead. That's it. So I guess if I had a question, if we were to use even at the 50% the natural gully system, and it all flows down into ultimately to Acacia Bay Road, my only concern would be the ability of that to withstand the extremes of stormwater.
Yeah, Mr. Bird, have you done the hydraulic calcs on that?
We have done modelling work as part, and it's reported as part of the application. Mm-hmm. First of all, to say that our intention is to make sure that post-development flows are trimmed back to their equivalent pre-development state for all storms. Mm-hmm. The comment of the 50% storm was really only the threshold at which we might start using the gully for detention. It was still intended that that detention would reduce flows down the gully. So yes, you're quite right that there is no culvert at Acacia Bay Road, and management of flow at that point is being looked at by Taupō District Council currently, but is not specifically part of this hearing. I would suggest nor need it to be, because we are trying to make sure that we are not creating a stormwater effect in that location. But the modelling does show that that location, even in the pre-development state in a 100-year storm, would overflow the road and flow on towards the lake.
So just, whilst that isn't, as you say, part and parcel of our current brief to consider, I take it that the catchment that we're talking about here is part and parcel of the modelling work that's being done on that particular culvert.
Yes, now I can't tell you too specifically, but I can tell you that WSP modelers have been involved in informing both the Nukuhau development and Taupō District Council's culvert investigation.
Right, right. And just for comfort on that issue, that the work is not just programmed for investigation, but there's also future infrastructure funding put aside for whatever remediation is required?
Yeah, unfortunately, I can't answer that. I'm not privy to that information.
Okay, right. Kevin, anything more?
No, I get the point that it's, Acacia Bay Road, where that lack of culvert is out of scope for us. But what we're considering is all of those gully systems flow naturally in that direction. That's where it all ends up. That's just that's the only reason I was sort of focusing on that.
Yep.
Correct.
All right, Dale, any other questions for Mr. Bird? No? All right, well, thank you, Mr. Bird.
Thank you.
Thank you, Mr. Bird. So we're moving on to archaeology, which probably won't get completed before lunch. I'm just wondering whether, rather than hold the witness over lunch, is it easier to take an early lunch now and then come back with archaeology?
If you think that's going to be a lengthy discussion.
No, I'm in your hands. I'm hoping not.
I wouldn't anticipate that that it would be a, well, I shouldn't anticipate, should I? It's your witness.
Yeah, I think we should keep going, Chair.
Righto. Let's have Miss Sykes, Sykes, isn't it? Yes.
Sykes, yes. Yep.
Sorry, not Skies. I have my Y's and K's the wrong way around. Sorry about that. Yes.
No, that's all right. My husband warned me when I took on his name that would be what I would get all the time, and it's proven to be true.
Right. Right.
Now, Ms. Sykes, you've got a statement of evidence that you prepared on the 20th of October, and you've also got a reply statement. I'll firstly just ask you to confirm the content of your statement of the 20th of October, and then just read from paragraph 10, which is the summary of that evidence, please.
Yes, I confirm that. So paragraph 10, I reviewed the ArcCheck high-level archaeological review prepared by my colleagues and which formed Appendix K to the PC 37 request. The results of the ArcCheck were that no specific archaeological risk was identified. 11, I carried out a site visit in July 2021 and prepared the archaeological assessment in September 2021. I identified 2 depressions on the site where there was considered to be archaeological risk, but the remainder of the site considered to have a low archaeological risk. 12, following provision of the archaeological assessment to Heritage New Zealand and further consultation with them, I'm carrying out additional analysis, and the WSP is commissioning work for the exploratory authority that Heritage New Zealand advises necessary. 13, in my opinion, the conclusion I reached in the archaeological assessment is that the proposed plan change and subsequent development of the site is expected to have minor negative effects on archaeological values.
Thank you. Now, turning to your reply statement, which is dated the 5th of November. This doesn't have a summary to it, but I'll just ask you to perhaps read from paragraph 5, and it may be that if there are some areas that you feel you can skip over because it has been read by the commissioners, you can skip past that, but just take it at your own pace, please. And I'm in your hands, Commissioner, as to whether you want to speed things up. I'll leave it to you to direct the witness.
I'm always in favour of speeding things up. That's part of this. So where you go, Ms. Sykes?
Please interrupt me if you want me to skip over something. Response to archaeological issues raised. Literature review. 5. The SOE of Ms. McCauley and the technical specialist report prepared by Ms. Linda Walters refer to the need for additional archaeological research in order to properly resolve the archaeological matters. Each information point in the TSR is specifically addressed in the following paragraphs. The TSR refers to the need for a comprehensive review of available archaeological literature from the Taupō region, particularly Williams and Walter 2003, and inclusions of the results of relevant archaeological investigations in the vicinity of the area subject to PC 37. I consider that the literature review and summary of relevant archaeological investigations in my archaeological assessment dated 7 September 2021 was sufficient to characterise the nature, to characterise the nature of the archaeology in this location. I consider the following.
Read. You can move on to the next paragraph. Yeah, thank you.
I specifically reviewed the literature sources listed in attachment 1 with a focus on looking at evidence for storage pits and gardening features. Williams and Walton 2003 was not reviewed in the archaeological assessment. I have now considered this report and any implications in regard to PC 37. Williams and Walton considered that archaeological research in the area at the time was limited to information recorded within the NZAA site recording scheme in an ad hoc fashion. It was noted that many of the recorded archaeological sites were pit and house sites, likely associated with mid to late 19th century occupation. 10. They outlined archaeological excavations to date within the Taupō area. These were mostly small-scale or salvage investigations, including a cave site and a 19th century settlement. More fulsome investigations included...
We might take that list as read as well, unless there's anything you particularly want to draw our attention to.
No, nothing in particular.
Okay.
11. Williams and Walton, 2003, considered that the Taupō area contained a fairly low population of Māori living in scattered villages, primarily around the lake and rivers, as well as occasionally on the bushline. Or current evidence suggested that sites from earlier periods have a limited geographical distribution along the lake and river margins. Settlement along the bush edge became more important in the mid to late 19th century as the bushline was pushed back further inland. 12. In addition, there is unresolved discussion in the literature as to whether climatic conditions for kumara growth was viable in the Taupō region. If it was viable, it was considered that sheltered microclimates would have been needed for gardening areas. 13. In regards to pits, Williams and Walton noted that they could have been used for store potato tubers, tobacco, and watermelons in the 19th century. 14. The archaeological assessment considered 15 archaeological sites in the NZAA archaeological site recording scheme within 7.5 kilometres of the project area, which were noted as depressions representing pits. I refer to Figure 1 and Attachment 2. While not as numerous as other regions, such as the Bay of Plenty, these sites do indicate that archaeological depressions are found throughout this landscape, albeit they have not been extensively investigated as the archaeological landscape appears under-investigated in general. 15. I would consider the literature review above supports the findings in my archaeological assessment in regards to the literature review and assessment of values. Consultation. The TSR refers to the need to consult with mana whenua to determine if there are any areas of cultural significance within the PC37 area, as this will also inform the probability of the presence or absence of archaeological sites. 17. Iwi consultation was outside of the scope of my involvement in the project. I note that consultation with mana whenua is outlined in Mr. Crawford's statement of evidence, and the section 42A report states at page 49.
Take that as thank you. Yeah.
Historical aerial photography. 18. The TSR refers to comprehensive examination of georeferenced high-resolution aerial photography taken in 1972 in order to search areas that were not able to be inspected during the field visit, and also search for any depressions similar to those in Area C. 19. I can consider that this examination was carried out as part of the archaeological assessment. Aerial photography were accessed and reviewed from the RetroLens website. The 1971 aerial photography, there was no 1972 aerial photography for the project area identified in RetroLens, did not indicate any other potential archaeological features included as figure 2, 3. Post-1900 land use. 20. The TSR recommends documenting the history of post-1900 land use, particularly focusing on the areas that could not be inspected during the field visit, as this will assist to determine if intact archaeological features are likely to be present. 21. I consider that the archaeological assessment suitably addresses this through the review of the aerial photography. The earliest aerial photograph dates 1946, shows the entirety of the project area has been cleared of any original bush and appears to be an open land with occasional trees, as per figure 3. The 1963 aerial of the project area shows little change from the 1940s, bar the occasional track and building within the project area, figure 4. By 1977, there is some ground disturbance in the central portion of the project area, but the majority of the properties continue to be in scrub or pasture. Some of the scrub has been removed by 1985, and by 2008, Area C is in forestry. Oh, I apologise, I believe that's actually Area A. The general land use appears to have had little overall disturbance to the project area since 1900, except for the area now in forestry.
Right.
Soil stratigraphy, 22. The TSR requests a comprehensive analysis of the soil stratigraphy examined during the field visit with relevant documented examples of culturally modified soils, for example, Simmons 2009. This will assist in determining if varied archaeological features are likely to be present. I consider this as addressed in the archaeological assessment and in Ms. Walter's report. Visual inspection and test pits outlined in the archaeological assessment report and Ms. Walter's report did not identify any modified cultural soils. Neither is described by Simmons nor seen previously by me at other horticultural sites throughout the North Island. 24. Other indications for archaeological gardening can include stone alignments, burrow pits, and/or markings from tools used to garden. I have noted none of these during the site visit. Storage pits, of which the depressions identified in Area C of the project may represent, while possibly indicating the storage of tubers, are not a guarantee of nearby gardening, as the tubers may have been transported. However, storage pits encourage additional examination of nearby soil profiles in search of potentially modified soils. As stated above, none were identified by me during my site visit. Area C, 25. The TSR requested that the archaeologists consult current and/or former occupiers of Area C to determine if the depressions identified during the field visit on 6th of July 2021 are of recent origin and relate to livestock farming activity or some other post-1900 use of the property. 26. My understanding is that the current owners of the subject property are not locally based. I spoke to the current tenant of the property during the site visit for the archaeological assessment report, and he reported having only been on the property for a few years. Additional recommendations, 27. The TSR's recommendations include the following to resolve archaeological matters. A, the archaeologists discuss with Heritage New Zealand whether the information supplied on 1st of October, which shows that the depressions in Area C do not appear to have been present in 1972, based on aerial photography examination, introduces sufficient doubt that the features are archaeological to allow for subsurface testing without the need for a prior Section 56 authority. B, if they agree, carry out sufficient subsurface testing to decide the origin and extent of the features and include the results in the revised archaeological assessment. C, only if the 1972 aerial photography evidence and the result of the discussions with the current and/or former occupants of the land does not establish to the satisfaction of Heritage New Zealand that the depressions in Area C are of recent origin, an exploratory archaeological investigation as provided for under Section 56 of the Heritage New Zealand Pohara Taonga Act 2014 should be carried out, focused on the area where the depressions are located and in the immediate surrounding land. There is insufficient time available to complete a Section 56 investigation before the scheduled plan change hearing date. 28. The following years of aerial photography were examined and the depressions were not clearly identified. Lens via retrolens.
Take that as read, that's fine. And the next one too.
30, continue from there.
Yep.
Extensive review of available aerial photography of the location of the two depressions proved inconclusive regarding their origins. The depressions were first identified as being visible in a 1989 aerial photograph. However, they are not visible in numerous photographs since then, including one from 2020. This would suggest the depressions may have been in existence prior to 1989 and were not visible on aerial photography prior to that. 31. As outlined in that report, the test pit undertaken during the archaeological assessment site visit would indicate that there is some depth to the depressions, as fill was identified for at least 40 centimetres below the bottom of the depression. The author considers this to be deeper than a typical farm trough or any that were noted on the property currently. No evidence of troughs or other explanations were noted on the aerial photographs examined. 32. This memorandum is intended to provide additional information for further discussion with the relevant stakeholders, including Heritage New Zealand, regarding the archaeological component of the project. In summary, the above responds to the recommendations outlined by Ms. Walters and as requested by Heritage New Zealand. I consider it supports the recommendations outlined in the archaeological assessment report. As per that report, it is recommended that additional archaeological investigation is undertaken under an archaeological authority at the time of subdivision and earthworks consenting.
Thank you, Ms. Sykes. Well done.
I've got one, Chair. I guess I'm interested to know if you anticipate getting any feedback from Heritage New Zealand during the course of this hearing, because I don't think we're hearing from them, are we, Chair?
Not on the list, no.
I also noted that, so I'm unsure on that. I'm happy to follow up, though, if that's considered a good idea.
Well, your recommendation, as I read it, is, as you've just stated, is that further work be done and that be somehow captured in either in the provisions or some other way. I was going to ask you the question on that matter as to whether or not, given the inconclusive nature of where we're currently at, whether in actual fact the structure plan should show the indicative depressions as part and parcel of the structure plan to provide a little bit more confidence, perhaps, to other persons that that isn't being lost sight of. You just comment on that?
I always think that it's a positive thing to add that onto any plan as an archaeologist, is to, as you say, not lose sight of that.
I mean, it can be put on. I mean, there are currently on the plan, there are 6 indicative features. So whilst I'm not a fan of indicative features on structure plans, there's so many already. Hey, what the heck, a few more. If we can resolve matters, as long as they are shown as indicative, because your further work may in actual fact demonstrate something to the contrary.
Yes, and I was...
Back to you. Sorry, yes?
My apologies.
Dale.
No, that's fine. Thanks, Chair.
Kevin, did you have any questions for Sykes?
No, I think you've covered it. My only question was, were they water troughs or were they not? So what you've said kind of covers that off.
Well, I wouldn't be quite so bold to suggest that, but yes. So Ms. Sykes, just tell us what's anticipated. I mean, if the plan change goes through, I mean, your brief presumably stops today, does it? You don't have a brief to conduct active investigations going forward?
I'm not based in Taupō, so my position would be that a more local archaeologist. I've previously been based.
That's fine. I wasn't asking you to bid for the job or anything. So that's fine. It was just a question as to whether or not there was any ongoing involvement in that matter. So that the answer is no at this point in time. But yes, Cleary, maybe you can after lunch you can have a think about that and come back on that prospect. I mean, the short point, as we discussed earlier, is that there is an authority that may well be required, and in the event that there is uncertainty, will almost certainly be required, because that's the way that NHP actually operates. Is if there's a doubt, then you require that investigation be done formally. So I would imagine that's going to happen anyway. But there are no other. I mean, from your evidence, there are no other archaeological features, artifacts, or issues arising from this entire area. That's correct. The short point, isn't it? Yeah. We have 2 depressions of unknown origin and unknown purpose, and that can be resolved. So thank you very much for your evidence.
Yeah.
Mr. Muldowney, I'm not going to press you to start traffic, that's for sure, before lunch. Yes. Question is, in terms of a lunch break, what's your pleasure, Mr. Muldowney?
Well, just looking at the program, I mean, it does feel as if we're pretty on track. The current program has got the applicant case finishing at 3 o'clock.
Yes.
We've got obviously traffic to go and then planning. So I would have thought that could be all cut out within 2 hours.
Yes.
So if we had, what are we now, 12:40? I mean, all it would take, I mean, it's signalling 45 minutes. That seems plenty for me, and we can get back into it within 45 minutes.
All right, well, just because I can't think in less than halves, let's go till 1:30 then, shall we? And resume at 1:30, and we'll
That's
see
great,
you all then.
thank you.
Okay, all right, talk then.
All right, thank you, sir.
Thank you.